Okay, so what we got a rebroadcast of the C-SPAN network doing an important hearing, which I think you all should hear. I don't think there's any copyright problems with it because it is a public station broadcasting on a public network. Whoops. And I think it's important for you all to see this, so I'm putting it up there. Enjoy.
And gives it to the president the power to execute the laws. And it puts the judicial authority, the power to interpret the laws, in Article 3 and gives it to the court. The separation of powers is crucial to liberty. It is what our country is founded on, and it's important, as consistent with my judicial methodology, for each branch to operate within their own sphere. That means for me that judges can't make law. Judges shouldn't be policymakers. That's a part of our constitutional design, and it prevents our government from being too powerful and encroaching on individual liberty.
Thank you, Judge. I mentioned in my opening remarks that the court has played a vital role, constrained within its proper constitutional boundaries in the national process of making America in real life what America is in text. And reflecting on your experience as a public defender, a vital role in our justice system, let's talk a little bit about the Sixth Amendment and the role that the court played in ensuring that the Sixth Amendment is real in practice in the Gideon v. Wainwright decision. Can you help all those who are tuned in right now to reflect upon that decision, what it means, what it says about the role of the court?
Yes, Senator. Prior to Gideon versus Wainwright, people who could not afford lawyers were not entitled to lawyers under our system. So a person could be accused by the government of criminal behavior and would have to fend for themselves in court. They would have to make their own arguments. Someone who is not a lawyer would still be responsible for defending him or herself in front of a judge if the government brought charges. Earl Gideon was a criminal defendant from Florida, my home state, who had a handwritten petition. He complained that it wasn't fair under our constitutional scheme that protects and requires people to be tried. He said, I need help. I'm not a lawyer. I can't make these arguments. I think it's important for the protection of liberty to ensure that people are able to have counsel. And that handwritten petition made its way to the Supreme Court. And the justices read it, and they determined to take his case, and in the end decided that the protections of the Sixth Amendment, the right to trial, includes the right to appointed counsel, so that everybody who is accused of criminal behavior now has the right to an attorney. And that's very important. I mean, one of the things that I see or saw as a trial judge is that it was crucial for our justice system to have representation from both sides. It was the only way that it is the only way that a judge can really make fair determinations. And in cases, we've heard a lot about my criminal cases. In every case, I'm getting, as a judge, arguments from the prosecution. I'm getting arguments from the defense counsel. I'm getting arguments or statements from probation in these criminal cases. And the work of a judge is to look at the facts and circumstances, hear the arguments of the parties, apply the law, and make a fair determination. And so having lawyers for criminal defendants aids in that process, and benefits us all in our criminal justice system.
I would just take the opportunity to note at this time, Judge Jackson, that it so happens that the Southern District of Georgia is one of just 3 federal districts without a federal defender's office, and I've offered legislation to establish one, and I'll be seeking support from my Republican colleagues to try to make that bipartisan to ensure there is access to counsel for defendants in my state. Let's talk a bit about the First Amendment. Freedoms of speech, publication, assembly. There's a well-known Supreme Court case, Brandenburg v. Ohio, which establishes a certain test to ensure that the government is constrained in any effort that may be made to punish speech. And the impulse to censorship is something that can emerge from time to time across the ideological and political spectrum, particularly in times of great controversy or in times of national security crisis. Can you please walk the committee and the broader public watching now from all across the country through that decision and how you will approach these vital protections for speech, publication, and assembly, should you be confirmed?
Thank you, Senator. Freedom of speech, publication, assembly is in the First Amendment of the Constitution. It is a core foundational protection against censorship. It is important in our constitutional scheme that people be allowed to express themselves, that ideas be exchanged. That is the groundwork for a vigorous and vital democracy. There are many tests, many cases in the Supreme Court's jurisprudence that discuss various disputes about circumstances in which the government can restrain or regulate speech. And that decision establishes to a certain extent that if there is speech that is an incitement to violence, that's one circumstance in which the government might be able to prevent it. But other than that, short of that, free speech is supposed to be allowed to happen. And there are, again, various tests and circumstances that the court has applied in deciding whether the government can regulate the content, place, and manner of speech. But the general principle is that our democracy thrives because the government is restrained and cannot censor its citizens.
I think in the same spirit of thanks with which I opened these questions, I also want to just take a moment and recognize the members of the press who are here, the reporters and photographers who ensure that these proceedings are truly accessible to the public, and ask you to describe your approach to press freedom. The question of prior restraint has been litigated. A famous case in the context of the Pentagon Papers in the latter years of the Vietnam War. I believe for all of us on this committee, we recognize the vital role of press freedom in ensuring the free exchange of ideas, access to truth and debate in our democracy. How will you approach cases that implicate press freedom?
Thank you, Senator. This is another area in which there is well-established case law that supports the freedom of the press to be able to write and report. There is a general obligation of truth in terms of the press, but also a recognition that sometimes there may be things that get published that aren't exactly accurate. And so the court in New York Times versus Sullivan determined a higher standard of liability for press. Things that are put out in the press have to be knowingly false. There's an actual malice test because the court was balancing concerns about libel, people claiming that they have been misrepresented in the press, with the need to allow the press to do their job. The overall understanding is that press freedom, again, is one of the First Amendment freedoms that undergird our democracy.
Something I just want to take a moment and observe, Judge Jackson, is, this is my first such proceeding. So I'm grateful to the chairman for opening today's ceremonies at the end of the dais. But something that I've studied and am aware of is that there's been a range over time of how willing nominees are to candidly and openly and forthrightly discuss these core matters of constitutional principle in proceedings like this one, and a tendency over time to allow less and discuss less, a more restrictive approach. And I want to thank you because while you have prudently and in a disciplined way, refrained from commenting inappropriately on potential pending case law, you have been willing to engage in a forthright and expansive discussion of these vital principles in a way that I think stands out among some recent nominees. That's not a criticism of any recent nominees. It's an observation about your performance. And I think that having an open and honest and forthright dialogue about these matters of national significance is part of the vital role that these proceedings serve. I want to turn now to the Fourth Amendment. I want to discuss with you the protections against unreasonable search and seizure. We discussed how the Constitution was a renunciation of monarchism and tyranny. It establishes core civil liberties, one of which is the protection against unreasonable search and seizure. How will you approach Fourth Amendment case law, and can you help those tuned in across the country remind them of what, for example, the principle of a reasonable expectation of privacy means in the context of Supreme Court jurisprudence?
Thank you, Senator. The Fourth Amendment is one of the amendments in the Constitution that protects individual liberty by limiting what the government can do with respect to criminal processes. It restrains the government from engaging in unreasonable searches and seizures. And the Supreme Court has developed a series of tests and ways of evaluating whether any particular act by an officer in a case qualifies as an unreasonable search or seizure. Let me just say that this is the kind of area of Supreme Court and judicial review that is very fact-specific, because courts, in order to stay in our appropriate role, can't make policy about police behavior writ large. Can't just sort of look out into the universe and say, we have a Constitution that says unreasonable searches and seizures, so let us tell you all what that means. That's not the way that courts operate. Under Article 3, courts can only hear individual cases and controversies and decide them. So every court, including the Supreme Court, is looking at unreasonable search and seizures in the context of a particular dispute where someone has had something searched by an officer in their house, they've been seized under a particular set of facts, and they claim in the context of a lawsuit or in the context of defending themselves that there has been an unreasonable search or seizure. And so the court, case by case by case, looks at the facts and circumstances and decides. And I would say that this is the kind of analysis that takes into account a number of things, but one of the things, in addition to understanding the facts and circumstances, is understanding what is meant in the Constitution by unreasonable search and seizure. There is case law that the Supreme Court has developed that looks at whether or not something is an unreasonable search and seizure, in part by analyzing whether there was a reasonable expectation of privacy in that item, in that area. Is there a reasonable expectation of privacy in your house, for example? If a police officer were to come into your house, you would not be able to claim Fourth Amendment protection unless, says the Supreme Court, there was a reasonable expectation of privacy in your house. And the Supreme Court has determined whether there's a reasonable expectation of privacy, for example, in your house, by looking at what areas were protected at the time of the founding when the words unreasonable searches and seizures were written into the Constitution. Lo and behold, something like your house, the court has determined there is a reasonable expectation of privacy because that's what those terms meant back then. And so if a police officer were to come without a warrant, the court has said, in areas where there is a reasonable expectation of privacy, that would be an unlawful search.
This is an area where the emergence of new technologies makes it likely, I believe, that should you be confirmed, you will have to consider Fourth Amendment claims in light of circumstances that couldn't have been anticipated at the time of the drafting of the Constitution. And indeed, constitutional interpretation has already evolved over time to adapt to the reality of new technologies. From phone booths, a classic case in the late 1960s about whether a closed phone booth door demonstrates an expectation of privacy, to more recent case law involving geolocation data from cell phones. And I want to urge you, should you be confirmed, to remain vigilant about how the emergence of new technologies, the way that they become ubiquitous in our lives, the way that virtual spaces are increasingly akin to physical spaces, will require the court to consider very complex questions and to seek technical advice, because these are technologically complex questions. What is your view on how the court should seek such technical expertise, which may be, with all due respect, beyond the training or experience of a justice or their clerk? And if, for example, one such method of seeking advice is through amici, what's the importance of understanding the provenance and origin and funding source of such briefs submitted to the court? So this is a two-part question. I want to restate it. The first is, again, I want to urge you, should you be confirmed, as I'm confident you will, to vigorously defend the constitutional rights of American citizens against unreasonable search and seizure in the context of new technologies. I'd like to hear how you'll approach seeking technical expertise to inform that decision-making. And then a question about the transparency of briefs filed before the court, something that Justice Scalia noted in some campaign finance case laws, that it's important for the public to know who's funding electioneering communications in the context of political campaigns. I think it's important for the court to know who's briefing them, what the motive and funding source of such briefs might be. Could you please, with my remaining time, and then I'll yield and we'll have some more time later to discuss war powers, could you please comment on those matters? Those will be my final questions for this round.
Thank you, Senator. One of the ways in which the court receives information other than directly from the parties in a case is through a practice, an established practice of receiving amicus briefs. Amicus is a term for friend of the court briefs. These are people who are not parties to the case, who don't have that kind of interest in the case, but may have expertise or information or arguments that they wish the court to hear. And I think that that would be the primary mechanism by which, if the court were to decide to hear a case concerning a matter that involves some technical expertise, I would think that there might be amicus briefs related to the technology, for example. I have not looked at the court's rules. I would certainly want to discuss with the court's other justices the ways in which determinations are made about which amicus briefs are received and what disclosures are related to them. But the court does receive amicus briefs in cases in order to inform itself so that it can make a decision related to the issues in a case.
Thank you, Judge Jackson. Thank you for your courage and your grace, your forthrightness in answering my questions. I look forward to the opportunity to ask a few more later, and I yield, Mr. Chairman.
Thanks, Senator Ossoff. Senator Tillis.
Thank you, Mr. Chairman. Judge Jackson, thank you for being here. I hope you got some rest last night, and congratulations.
Very little, Senator, but that's all right.
Me too. But thank you for being here, and congratulations to your family and your husband, who has an impressive medical list of accomplishments that he should be proud of. I'm sure that you are too. And thank you to your family, the public servants, serving in the military, serving in law enforcement, educating our children. You're a role model family. I do want to go back. This morning, I ended up turning to a channel that I never watch, just to see what was being said about the proceedings. I thought it was interesting that they were ridiculing some of my colleagues on this side of the aisle for bringing up the behavior of past Supreme Court hearings. This is really the appropriate venue to do it. I guess we could talk about it when we're reviewing intellectual property or something else, but contextually, this is the time to do that. And I think we all have to agree that the behavior in the Kavanaugh hearing was inappropriate. I hope we never get back to it. And I hope we can all agree that many of the behavior or the positions that some of my colleagues took on the other side of the aisle with Justice Barrett was abhorrent, and we should never do it again. That's why I'm so glad that for the most part, we behaved in an appropriate manner here. I'm going to get to some questions, if time allows, that relate to some other questions that my colleagues have asked. But Judge Barrett, did I understand correctly that at a young age you won a debate competition, or was it oratory competition?
I was in speech and debate. It was one team, and I did original oratory as my primary event.
And did you continue your debate competition? Did you continue to do that? First question. Did you continue to do debate competition?
Continue into
Yeah, I mean, were you
college?
doing that in school and college?
I did not do it in college. No, I did it from middle school through high school.
Okay.
And stopped when I graduated high school.
I did too, and I recall with that we would get assigned a topic that wouldn't necessarily be one that we agreed with, but we had to argue it. Were you ever in a situation, or did you get to pick a topic and only argue the side that?
So I didn't do what it sounds like you're referencing is extemporaneous speaking.
Yeah.
I think I did that once in one competition. I did original oratory, which is where I wrote my own speech.
Okay, you've had an opportunity to debate a lot as a defense counsel, I would assume, in the court of law when you're debating a position. And the reason I ask that question is that yesterday when Senator Kennedy was asking you about the expanding the court, or what we call court packing, you said, I haven't really thought about it, but I hear the arguments on both sides. And I hear the argument on both sides. So could you briefly describe to me your perception of the arguments on both sides?
My understanding of the argument is about whether or not to expand the court beyond the 9 justices that are on the court right now, the 9 seats that are there. And
If you were to view, I mean, right now it's 9 is fine, 4 or more. I mean, that's really the 2 arguments. So do you understand, or have you heard any of the arguments for or against either side?
I'm not even sure about the 4. I've just heard people talking about
Okay.
putting more justices on the court, expressing concerns that the court has become politicized, that the court has become unbalanced in terms of what people perceive to be views of the majority of the justices. And so I've heard arguments about rebalancing the court on that side. And then there's the argument that many on the dais have stated about the inappropriateness of doing so, the concern that it might lead to some kind of a war of every time there's a new president adding justices to the court.
Actually, yesterday when Senator Whitehouse, I think it was Senator Booker, who observed Senator Whitehouse's presentation, made a comment about how Rhode Island, New Jersey being a bit bigger, would have a bigger graphic to display. I went back, I think that New Jersey is 6 times the size of Rhode Island by square miles. North Carolina is 36 times the size of Rhode Island. And before my friends from Texas chime in, I would let them know that if Alaska were 2 states, they'd be the 3rd largest state. So I'm decided to use the White House format for dark money so that we have a balanced understanding of the fact that our proceedings here, the aspirations for the court, there is an ecosystem out there on both sides. As a matter of fact, we had a judicial nominee who actually participated in this ecosystem. I think you could reasonably assume if they participated in that ecosystem that they probably would have been an activist judge. The point that I make here is that we've seen this ecosystem mobilized to support you, and I think, Judge Jackson, you said you haven't had any encounter with Demand Justice. I don't know if you've had any encounter with some of these that are abbreviated, or I'm sorry, either acronyms or abbreviated, so I wouldn't expect you to. It would be interesting if we could, for the record, determine if you have had any interactions, but with respect—
I have not, Senator. I've never seen most of those.
That's good enough for me. I wouldn't expect you to be honest, sitting on the bench, but they are out there, and they have a specific plan. And their specific plan, as a matter of fact, I was inspired by Senator Whitehouse's seat, so I went out to Demand Justice. They have a specific plan. Step 1, 4 seats on the Supreme Court. We must add 4 seats on the Supreme Court to restore balance, which by their opinion is a majority with their view and their judicial philosophy. They're thrilled that President Biden has promised to appoint a commission. In fact, they're so thrilled that they want to make sure that they can influence the outside of the commission by endorsing their 4-seat strategy. They want to recruit 25,000 volunteers. This is on their website, their strategy, to influence the commission's recommendation. And then they want to nuke the filibuster. 51 votes to make a decision that could ultimately be to pack the courts. This is their stated goal. They're proud of it. Senator Whitehouse was talking about how the prior president was influenced by an organization. I would say that Senator Jackson and almost everybody that the president vetted before, Judge Jackson, are on this list. So I think it's intellectually dishonest to say that the administration, that my colleagues on the other side of the aisle, are not influenced by this organization. We've tracked some of the fundraising and support in re-elections. They're engaged, and they're influenced by it. But let me tell you what I'm really worried about with the court packing risk that we have today. We're talking about the ultimate destruction of 2 institutions. Back in January, Senator Schumer laid a vote down on the floor that ultimately would have reduced the majority of 60, the filibuster limit of 60, to 51. He was doing it as a way to pass a single bill, but we all know what happened when Senator Reid nuked the executive calendar for circuit court judges. It led to you only being subject to 51 votes to be confirmed. That nuked the executive calendar. In January, Senator Schumer was laying the groundwork for the same thing. Now, I worry that that's the destruction of the Senate institution as far as I'm concerned. I think we have to be a consensus-based organization. We don't need to be a 100-member House of Representatives. And that vote happened. What disappointed me most about that vote is back when President Trump was calling on us and pressuring us to nuke the filibuster when we had control of Congress, I signed on to a letter with more than 60 members to say that I would never do that in the face of a Republican president whose policies I supported. I did that to send a very clear message. I respect this institution, and I respect the court, which almost certainly would have been, we would have had pressure from our side of the aisle to pack the court a little bit more. Now, every member who was here back when we signed that letter, who's on this committee, changed their position and voted to potentially nuke the filibuster just 2 months ago. So I hope you can understand my concern about the political winds and the potential damage that it could do to the Senate and do to the Supreme Court. I think it was Federalist Paper 78, where Hamilton talked about the vulnerability, or I think the feebleness. Now, he was arguing, I think, the case for lifetime appointments. But I do think that the Supreme Court is a fragile institution. And I do believe that if we think it's politicized now, think about how it would be if we destroy the institution of the Senate so that a strict party line partisan vote, we expand the court. That's why court packing is important, and that's why we ask a question that I know you're not going to answer, but I know that Justice Breyer and Justice Ginsburg did. And if there's any Supreme Court justice listening right now, I wish that they would speak up, because I think your institution is in peril, and accelerating it to a truly political body is only one successful nuking of the filibuster vote away in the U.S. Senate. This is serious stuff. I was at Price Waterhouse. I was a partner at Price Waterhouse back during the Arthur Andersen Enron scandal. I saw about a 100-year-old top-tier Big Five consulting firm cease to exist because their reputation suffered. If we pack the court, the only thing that you all have, that the Supreme Court has, is its integrity and the esteem that the American people and the trust that they put into it. Packing the court could cause the Supreme Court to lose the trust of the American people. And I think if we want to expand the court, let's do it for the only valid reasons. Maybe the justices come to us and the Chief Justice come to us and say, the workload is too great. The times have changed. And then convince 60 members of this body to consider it. But when you've got a partisan organization here that's putting a pipeline of people in there that they think like them and have a judicial philosophy like them, how can any reasonable person think that this is just kind of fixing the mechanics? It's a partisan decision that even some of my colleagues on the other side of the aisle have taken the bait. So much so that they would reverse a commitment that they made with me when they signed that letter to say they would never nuke the filibuster and then nuke it. President Biden's on that list too. Back in 1983, he gave a rousing speech in a Judiciary Committee hearing saying, don't pack the court. He gave a rousing speech on the Senate floor saying, don't nuke the filibuster. But now we're in this posture to where we could destroy two institutions if we're not careful. So I actually hope that you can at some point study the issue thoroughly and understand the risk to this institution that you're likely to be confirmed to. It's serious. And you could end up being there. You'll have a lifetime appointment. You could actually be there and witness its demise real time if we allow the court to be packed. Now, I want to talk a little bit about I think you were a part of a case in Massachusetts that some people are casting as a pro-life versus pro-choice issue. Now, to be clear, I am Catholic and I am pro-life, and I'm proud to have signed and ratified pro-life bills in North Carolina when I was Speaker of the House that have withstood judicial scrutiny. But I don't really think that case was about pro-life. I think it was about free speech. So I want to ask you a few questions about it. And maybe you could describe it to me if your memory serves you. But it seems to me that the argument that you were a part of, I think that you joined with a couple of others, it seemed as if the argument was because the pro-life protesters were threatening and dangerous to women, attempting to enter the clinic. I'm not necessarily saying you put those words in the brief, but they were in there, and they were a hostile, noisy crowd in the face of protesters. Now, am I correct that a part of the argument was because they were noisy, in-your-face protesters, they needed to be a little bit further away than people who were pro-choice advocates? Because as I understand it, I think the underlying law in Massachusetts was ultimately struck down unanimously by the Supreme Court. Is that correct?
Thank you, Senator. The brief that you...
Oh, by the way, I didn't expect you to respond to my riff on packing the court.
Yes.
Just to net it out, it's a bad idea. But back on this.
I understand. The brief that you are referencing was a brief that I worked on right after finishing my Supreme Court clerkship when I joined a big law firm in Massachusetts. This is maybe 2000 at the end of my clerkship. And it is a First Amendment free speech set of arguments that the lawyers at my firm, I was a part of a team representing clients who wanted to make an argument about buffer zones, which at that time had not yet been litigated all the way up to the Supreme Court.
Was it a buffer zone that put pro-life and pro-choice people in the same buffer, or one that argued that pro-life people were in your face and perhaps needed a bit bigger buffer than the pro-choice? I was just trying to understand the facts of the case.
I believe that it was viewpoint neutral, meaning it wasn't about what the people were saying. It was about clearing a path to allow people to enter the clinic. Mm-hmm. The laws at the time were about how far did people have to be kept back, whether they were pro-life or pro-choice, because if they were blocking the entrance.
Do you understand why the underlying law was ultimately deemed unconstitutional by the Supreme Court?
I didn't follow the jurisprudence. At that time, it had not been. And the First Circuit, this was a First Circuit brief. I don't remember what happened in the district court, but my clients wanted to argue in the First Circuit that the laws that allowed for the clearing of the path so that people could enter the clinic and have people stand back were constitutional and important, and the First Circuit agreed. I think ultimately, I don't know exactly, but I think ultimately, as you say, there was some litigation that went all the way to the Supreme Court, and the court had other jurisprudence about the extent to which buffer zones are constitutional.
Yeah, well, it looked at, I'm not an attorney. I watch Law and Order from time to time, and I'm not going to get into a debate, but on its face, it almost looked as if there was this notion that there was bad speech and good speech, that somehow, look, I'm somebody who's had protesters come to my house, get in my face, and be very nasty, 4 times by land and 2 times by sea. I live on a lake. Okay with them doing it as long as they stay off my lawn. In the last case, they didn't. But it almost felt like to me that those protesters who didn't like me needed to be a little bit further away than the protesters that maybe I would allow to be a little bit closer. It may not be right, but I'll make sure that I get my facts right before this afternoon in the second round. I want to go to sentencing. I'm not going to cover any of the ground that my colleagues have. I'm sympathetic to some of it, not necessarily all of it, because I think the details are something that we don't have possession of. I'm sure we're going to talk a little bit more about that. But I want to talk more about a pattern. I know, and I was really impacted by your description of family dinners and your uncles coming in uniforms and putting their guns up on the cupboard and having a sense of pride that you had family that served in law enforcement. There are a couple of cases. I'm very focused on law enforcement and backing the blue. I think that law enforcement, I talk with a lot of them, their morale is low. They feel like defund the police and some of these other efforts are already making a very difficult and dangerous job more difficult and more dangerous. There have been a few cases where you have recommended lower sentences that even I think the defense attorneys have. But I'm sure that if I were you and observing you yesterday, you would probably point to some mitigating circumstances or factors that are not necessarily available to the committee as a basis for doing that. I think in one case, the government recommended a 30-month sentence and the defense recommended 21 months and you gave them 18 months. And this was a third conviction for assaulting an officer. There was another one that was a lower sentence for, there were officer assaults, and it just seemed like it went lower. But I don't want to get into those because you may have factors that that you would point to that would justify the decision. I've got a question about, now, see, that's at an atomic level. I mean, you're looking at the facts of the case, you're looking at the defendant, and as you've described in some of the other cases here, you made a judgment that you thought was fair and that was in bounds with your peer group. But back at the beginning of the COVID pandemic, I believe you made this statement, and I'll give you time to provide context if it's out of context, but in the interest of time, I'm only going to read the most striking. You said the obvious increased risk of harm that the COVID-19 pandemic poses to individuals who have been detained in the districts, that's the District of Columbia's correctional facilities, reasonably suggests that each and every, and I think that means everyone, every defendant who is currently in the D.C. Department of Corrections custody and who thus cannot take independent measures to control their own hygiene and distance themselves from others should be released. I checked in April of 2020, I think that's when you made the statement, that there were 12 or 1,600, let's call it 1,200, I'll be conservative, people in the Department of Corrections. Do I read that statement to say that you felt, given the circumstances of the time, they should all be released? Because that's broad. That's not looking at their individual cases.
No, Senator, you don't read it correctly.
Okay.
It was not a statement. It was a line in an opinion. And the beginning of the COVID-19 pandemic was a really, obviously, horrible and difficult time for all of us. And what was happening at the beginning in the prisons, which was part of the criminal justice system that as judges we were involved in.
I tracked it quick. Because I do not want to go over. I don't go over.
Can I just?
But let me just give you a little bit more context. I've actually written letters to the Department of Justice encouraging the release of nonviolent offenders in North Carolina at a federal correctional facility. I've also supported early release programs. I voted and supported the First Step Act. I, as Speaker of the House, was the first speaker in probably 2 decades that actually did the Justice Reinvestment Act early release of nonviolent prisoners. But how can I not read this to say that perhaps they should be released irrespective of the crime for which they've been charged.
Senator, if you read two more sentences down, that is precisely what I focus on. This is a case, United States versus Wiggins, where I was setting up my analysis as to why I would not be releasing Mr. Wiggins in this case. He was arguing essentially what I said in that statement. He was arguing that the circumstances of COVID-19, which at that point was rampant in the prisons, we had not had a vaccine, there were very difficult circumstances for prisoners who could not be separated from each other in the context of our jails. And as I say at the beginning of that opinion, at that point, COVID was ravaging the jail. And the question for courts under the statute that Congress has enacted for compassionate release was whether COVID-19, a pandemic in the jail, was an extraordinary and exceptional circumstance or extraordinary and compelling circumstance that should warrant release. What I said in that statement that you read was it would seem as though something like a deadly pandemic rampant in the jails would justify releasing everyone. But I go on to say in that very opinion, Congress has indicated that we have to take each case individually. We have to look at the harm to the community that might be caused by the release of individual people. We can't just release everybody, I said in that opinion. And so
I wanted to give you, I'm sorry to interrupt you, but I'm on,
that's all right.
on 4 minutes. But I feel like I also had my staff provided me this morning in very, very small type, recidivism and federal sentencing outcomes. I've said, I'm on record as saying that I want people out. I want them to have them an opportunity to reenter society, become productive members, and I've got a track record for ratifying bills to that effect and supporting similar measures since I've been here in the Senate. I'm going to continue to work on it. But tell me why the numbers that I'm looking here, we have recidivism rate, the most recent one that I have before me, and I'd be happy to share it. I'll ask with to have this submitted to the record. But I think an 8-year look back says that 49% of the people incarcerated are rearrested within 8 years. If you take a look at the types that are most likely to be reoffending, it's firearms offenders, robbery offenders, violent offenders reoffended at a higher rate than nonviolent offenders. And so if I look at this and I look at your philosophy with respect, and it's admirable. I said that the content of your character would be demonstrated this week in my opening statement, and it has been. And one of the things that are first among them are your compassion and your belief that people can redeem themselves. But if you look at some of the cases that my colleagues have brought up, and if you look at even with the context that you provided on the last statement about the Department of Corrections statement in Wiggins, can you understand how some of us may think that your compassion could lead to bad results based on the numbers that we have here with recidivism, that Congress may need to work more on that to make sure that we get it right? Can you understand how somebody who, from our side of the aisle, could see that maybe there is some pattern to give the benefit of the doubt to someone who has been incarcerated, in some cases with very serious crimes?
Thank you, Senator. I don't recall saying anything about compassion in the way that you're describing it.
No. I'm just saying that if I take a look at your responses to some of my colleagues' questions and your statements to some of the to some of the defendants. It seems as though you're a very kind person and that there's at least a level of empathy that enters into your treatment of a defendant that some could view as a maybe beyond what some of us would be comfortable with respect to administering justice.
Thank you for letting me clarify. The statements that I made about my practices as a trial judge, which I'm no longer a trial judge, but were intended to explain how trial judges operate and how they impose sentences within the framework that Congress has provided. The statute that applies to us tells us to look at all of the various factors that Congress has set forward, including the nature and circumstances of the offense, the history of the and characteristics of the defendant, and it tells us that we should be imposing a sentence sufficient but not greater than necessary to promote the purposes of punishment. Congress also tells us that one of the purposes of punishment is rehabilitation. My attempts to communicate directly with defendants is about public safety, because most of the people who are incarcerated via the federal system and even via the state system will come out, will be a part of our communities again, and so it is to our entire benefit, as Congress has recognized, to ensure that people who come out stop committing crimes. And so what I convey, or did when I was a trial judge, as I sentenced people to very lengthy periods of incarceration, was you are getting your day in court, you are able to say what you want to say, but you have to sit here and listen to my reading into the record the victim statements in this case. You have to go away understanding that I am imposing consequences for your decision to engage in criminal behavior. And the reason why I did that, I've said, is because I recognized as a defender that there were lots of people in our system who, instead of taking responsibility for what they had done and then ultimately understanding the harm and potentially not doing it again, instead of that, those people were bitter, they were angry, they were feeling victimized because they didn't get a chance to say what they wanted to say, because nobody explained to them that drug crimes are really serious crimes. Nobody said to them, do you understand that there are children who will never have normal lives because you sold crack to their parents and now they're in a vortex of addiction? Do you understand that, Mr. Defendant? I was the one in my sentencing practices who explained those things in an interest of furthering Congress's direction that we're supposed to be sentencing people so that they can ultimately be rehabilitated to the benefit of society as a whole.
I appreciate that, Judge Sachs. I just still note that virtually half of those people, statistically speaking, that you gave that speech to within 8 years were back in prison, and in some cases for more serious offenses than the first incarceration. Thank you, Mr. Chair.
Thanks, Senator, for that line of questioning. And I've noted that you joined a letter with Senator Grassley and myself in March of 2020 at the earliest stages of this, talking about release under these similar circumstances. And of course, we all said at the same time, low risk inmates would be considered, but
Only low-risk inmates.
yes.
Yep.
And I wanted to make that note for the record. We're going to start the second round of questions, 20 minutes each, and I'll kick it off. This is an unusual document, this Constitution of ours, which has taken up so much time in the hearing, the conversation about it. And it is really at the core in any branch of government without taking an oath to defend this document. I don't know about other countries and the oaths that might be required, but we even within the Constitution spell out the oath to be taken by the President of the United States, and it's to uphold and defend this document. And there's great debate about just what this document means in today's context. We understand the wisdom, the inherent wisdom of the document, and the fact that we're still here some 230 years later with the design of a government that has endured longer than virtually any other democracy, which, of course, speaks to the wisdom of the Founding Fathers and their plan for this nation. But we also understand, taking an honest look at it, that you barely get into this document, Article 1, Section 2, then you run into a problem. Because in Article 1, Section 2, the article that relates to Congress, they talk about who will be counted for apportionment among the states, and there is that awful reference to 3/5 of all other persons, which, though the document never mentions the word slavery or slaves, what was being spelled out here by the Founding Fathers was, how are we going to count these slaves? And for apportionment purposes, they were to be counted as 3/5 of a person, which is a horrible notion by any standard, but the wise Founding Fathers included it, trying to deal with the reality of their day. I hear debates back and forth of originalists, textualists, and others, and you've been asked as often as any nominee what your thought is. You've talked about stay in your own lane judiciary and methodology and like. But I'd like to explore for just a moment, without asking you to get in any particular fact pattern, the reality of a couple things. First, when the Bill of Rights was written, the First Amendment to it made certain to guarantee freedom of press. Freedom of the press in 1790 was, of course, referring to a piece of paper, a newspaper, and saying that there would be freedom to engage in that process in this democracy of America. Now that freedom of press is referring to this, and things have changed an awful lot. We have a circumstance now where people no longer have just a handful of television networks or known publications, Washington Post, New York Times and such, but turn for their sources of information to places like Facebook and Twitter and beyond. And we have a real serious question about what is a publication in America? What does it take to be a publication and be press? Is my blog that I publish tomorrow the press, guaranteed with a constitutional right that I have a right to publish it as I wish, say what I want to say with certain boundaries? And I guess my question to you as we look at this is, how do you move from the language of 1789, 1790 to the reality of 21st century and make sure it's relevant? If more people are relying on Facebook and Twitter, for example, for information than they are common sources of television and newspapers, how do we rationalize that they can say, Facebook and Twitter, to a former president of the United States, you can't publish here. You're not going to be allowed to do it, and they've done that. So how do you reconcile that conflict of the changing times, the dramatic changes in technology, what the Founding Fathers envisioned and what we face today?
Thank you, Senator. The challenges that you identify are the types of things that the Supreme Court is now dealing with. We have a foundational document that has text and it has principles. It establishes freedoms and foundational important concepts that are intended to govern us and that we are bound by as a society. There's modern technologies, as you say, that have not, that the framers, the founders could not have imagined, the cell phone and all the other things that we now rely upon. And as I mentioned earlier, the Supreme Court and every court deals with individual cases, disputes about issues, and when the court gets an issue that requires constitutional interpretation, it looks at the facts and circumstances of the particular case and the text and principles of the Constitution in light of the times in which they were written and analogizes to present day. So the Supreme Court, for example, has considered the cell phone issue with respect to the constitutional principle of unreasonable searches and seizures, which is a protection from government intrusion that the framers called an unreasonable search. The text unreasonable search does not have an inherent definition. What the Supreme Court has done is looked back at the time of the founding to determine what kinds of intrusion would have been covered when those words were written into the Constitution. And to the extent that at the time of the founding, those words covered things like police officer intruding into your home and looking into your papers and affairs, then the Supreme Court analogizes that circumstance to the modern day circumstance of a cell phone, which now is in all respects, says the court, like rifling through your papers and affairs. So it's a process of understanding what the core foundational principles are in the Constitution as captured by the text, as originally intended, and then applying those principles to modern day.
I'll just give you two illustrations of my thinking on this and my frustration, or at least understanding of the challenge, let's put it that way. Senator Feinstein and I joined in legislation several years ago to talk about confidentiality of sources for news entities and whether or not a reporter could be compelled to disclose those sources. The effort really drew some of the best and brightest in the news business to come testify for the committee. The effort failed and faltered over what is a publication, who is a publisher, who is in the business of dispensing news. Does it involve money has to pass between them for this to be an official publication? Or can I just put up on my blog what I wish and resist any efforts to discover my sources? That was one of the serious issues that we faced. We also took a look, I take a look at where this is going in terms of the future and our entities that we rely on for news so often. And I'm going to leave it at that because I think you've addressed the general and don't want to get into more specifics, nor should you. But when people pledge that, they are originalists, we're sticking with the original words, you better have your mind open to the reality that this world is changing and changed, and many of those principles are sound today, but the challenges of interpreting them with the reality of today's technology is a challenge, a very difficult one, which you would face in the court. I'm going to try to set an example here. We have 20 minutes, and I'm going to try to yield back some part of it. I see that Senator Cornyn is here, and I'm glad he is because I'm going to address an issue which he raised yesterday and again this morning. And I wanted to do it while he was physically present so that when he gets his turn, he can address it. I'm sure he will. Yesterday, Senator Graham said that you had gone too far in calling the government, quote, a war criminal and pursuing charges against a terrorist. Later, Senator Cornyn asked Judge Jackson, I quote, you referred to the Secretary of Defense and President of the United States as war criminals. Why would you do something like that? As I noted yesterday and repeat this morning, these charges don't hold up. CNN fact check said, quote, both Graham and Cornyn left out important context. Specifically, neither mentioned that Jackson's allegation of war crimes was about torture. Also, Jackson didn't explicitly use the phrase war criminal. The New York Times noted that the allegation, quote, is a distortion and lacks context. The New York Times went on to say, Judge Jackson did not specifically call the former president and defense secretary war criminals. She was one of several lawyers in 2005 signing 4 essentially boilerplate habeas corpus petitions on behalf of detainees at Guantanamo that claimed the U.S. government had tortured the men and that such acts constitute war crimes, that's in quotes. The petitions each name Mr. Bush and Mr. Rumsfeld, along with 2 senior military officers who oversaw the Guantanamo detention operation in their official capacities as respondents. Washington Post noted, and I quote, one key thing to note, as law professor Stephen Vladeck does, is that Bush and Rumsfeld are named in petitions because they have to be, to clear procedural hurdles. Indeed, those petitions later named Barack Obama after the administration changed. Another is that they are named in their official capacities, not because of actions they personally took as individuals. They continued, but the larger point is that Jackson was acting as a detainee's lawyer in her role as public defender, and one of the underpinnings of the American justice system that is even the most reviled alleged criminals have the right to a vigorous defense. Would you like to comment on that statement that I just made?
Well, Senator, I would just say that public defenders don't choose their clients, and yet they have to provide vigorous advocacy. That's the duty of a lawyer. And as a judge now, I see the importance of having lawyers who make arguments, who make allegations. In the context of a habeas petition, especially early in the process of the response to the horrible attacks of 9/11, lawyers were helping the courts to assess the permissible extent of executive authority by making arguments. And we were assigned as public defenders. We had very little information because of the confidentiality or classified nature of a lot of the record. And as an appellate lawyer, it was my obligation to file habeas petitions on behalf of my clients.
Thank you, Judge. I'm going to try to set an example by yielding back about 7 minutes of my time. I invite my colleagues to follow that example if they wish. Senator Grassley, you're next.
Yeah. Before I start, I'd like to make a brief point. Yesterday, Senator Durbin referenced Congress's effort to stop child pornography and the exploitation of minors. I've worked on this issue for decades. In 1983, I supported the Protection of Children Against Sexual Exploitation Act. In 2012, I sent a letter to the Sentencing Commission while Judge Jackson was vice chair. In the letter, I encouraged the Sentencing Commission not to lower sentences for child pornography. I said that, quote, it would be a disservice to the American people to have the commission issue a report that advocates for the reduction in sentencing for a class of criminals who cause profound and lasting damage to their victims, end of quote. I'd like to have that put in the record.
Without objection.
Yesterday, you referred to your record of decisions as the best thing to look at when explaining and evaluating your nomination. But you also said that you haven't had enough cases involving constitutional law to develop a judicial philosophy. If you haven't had to develop a philosophy for deciding cases yet, what else do you think would be helpful for us to look at?
So respectfully, Senator, I do have a philosophy. The philosophy is my methodology. It is a philosophy that I have developed from practice. Unlike some judges who come to appellate work from academia, and who have some overarching theory of the law, I approach cases from experience, from practice, and consistent with my constitutional obligations. So my philosophy is one in which I look at cases impartially, consistent with my independence as a judicial officer. I understand my limited role in the constitutional scheme and therefore take very seriously all of the constraints on the exercise of my authority that exist in our system. What that means is that at the beginning of every case, I am setting aside my personal views.
That's the three steps you gave us.
Yes, sir. That,
Date.
yes.
So you don't have to go into that. Let me go on then. Should the Supreme Court overrule a precedent when it is clear to the justices that the precedent was wrongly decided?
Thank you, Senator. Stare decisis, which is the principle that the Supreme Court uses at the outset. It's the sort of background rule of judicial maintenance of precedents in order to have predictability, stability in the law, is the kind of principle that the court begins with when it is asked to overrule or revisit a precedent. And the court has developed certain factors that it looks at before it actually undertakes to reverse a precedent. One of those factors is the view that the precedent it's reconsidering is wrong, but that's not the only factor. The court also determines, in addition to whether or not the prior precedent was egregiously wrong, the court has said, the court looks at whether there's been reliance on that prior precedent, whether the precedent is workable or has proven workable over time, whether the cases in the area of the precedent have shifted such that the precedent itself is no longer on firm foundation, and whether there have been either new facts or a new understanding of the facts that give rise to a need to revisit the precedent. So it's not just a look at whether or not it's wrong, and it's important that the court take into account all of those factors because stare decisis, meaning letting the precedent stand, is a very important pillar of the rule of law.
When is it appropriate for a judge to impose a sentence enhancement under the guidelines?
Thank you, Senator. The federal sentencing guidelines are crafted to assist courts in making sentencing determinations within the broad range that Congress prescribes for cases, for crimes. So in the typical case, a defendant is convicted of some crime. In the federal system, they're usually very serious crimes. And Congress will say, Judge, you can give that person a sentence anywhere between 0 and 20 years, for example. The sentencing guidelines are designed to set out a series of factors that judges should be looking at when they decide what they're going to sentence that particular person to. And those factors will be things like, if this is a violent crime, does the person have a weapon? If this is a violent crime, was there any injury? And so the judge is looking at these facts, in many cases horrible facts, and calculating the guidelines based on what we call enhancements. Each one of those different characteristics or conditions is an enhancement. So you ask, when is it important to
Appropriate.
when it's appropriate. Well, the judge has to calculate the guidelines in every case. That's how we start the process. But under the statutes, in addition to calculating the guidelines with all of those enhancements, the way our system now works is you determine what the guideline range of punishment is going to be. And then Congress says you look at a series of other factors in addition to the guideline range. And at the end of the day, the judges in the system now are choosing sentences based on both the consideration of the guidelines and also the consideration of the statutory factors that Congress has put forward.
Have you ever declined to impose an enhanced sentence on a defendant because you disagreed with the enhancement as a policy matter?
Thank you, Senator. Yes, and the reason is because of Supreme Court case law concerning the way in which the guideline system operates. The Supreme Court has determined in a case we discussed yesterday that the guidelines are no longer binding on judges, meaning the guidelines you calculate, but you don't have to stay in the guideline range anymore. That was the Supreme Court's Booker case. And I can't remember if it's in that case or in subsequent case law, but the Supreme Court has also made clear that when you are calculating the guideline range in the new system that we're in right now, judges are free, the Supreme Court has said, to decide in particular cases whether as a quote-unquote policy matter, they disagree with a particular enhancement. That is the state of the law. That is what the Supreme Court has said judges are permitted to do in cases. And so I have, in certain cases, given the way in which the guidelines are operating, the disparities that are created in cases, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has said that that's the authority of a sentencing judge in our system.
Are nationwide injunctions constitutional?
Well, Senator,
You've issued them.
thank you for letting me address that circumstance. The reason why I paused is because what I have issued is not technically a nationwide injunction. People call it that, but see cases that are brought under the Administrative Procedure Act. These are challenges to agency actions, like agency rules that they have promulgated. And if the challenge is to the procedures that the agency undertook to create the rule, the statute that applies, the Administrative Procedure Act, tells the court that if you agree with the plaintiff that the agency rule is faulty procedurally, the remedy in the statute is to invalidate the rule. That's what Congress tells judges to do. Now, technically, that's not a nationwide injunction. That is invalidating a rule that the agency has enacted. It may have nationwide effects because the agency may have implemented its rule nationwide. But what the court is doing is not reaching out and touching everyone in the country. The court is directing the government that has promulgated that rule that the rule is invalid. And that's what the statute tells us we have to do in those cases. That's different than a nationwide injunction because a nationwide injunction would be a situation in which we're not dealing with the rule, we're not dealing with the Administrative Procedure Act, we're dealing with a particular case in which something has happened between the plaintiff and the defendant, and the court says, based on what happened in this case, I'm going to tell everybody in the country that you can't, the defendant, you can't operate in this way anymore. I'm going to find on the basis of this particular case, and I'm going to enjoin everyone in the country not to do that anymore. That's a nationwide injunction, which is not what I've done in, I think, the cases that you're talking about.
How can the judiciary address concerns about forum shopping, given the rise of nationwide injunctions?
Well, forum shopping is a concern that arises when litigants seek to go to different places in the country where they think that they may get a better result. And it's something that Congress can address because Congress has the power to determine various aspects of judicial process.
Explain the political question doctrine, and then what standards would you apply to determine whether a claim before you implicates a political question?
So the political question doctrine is a doctrine that relates to the jurisdiction of the court. As I mentioned, the courts are in a particular branch of government, the judicial branch, that is limited in its power. The courts can't make policy. They can't reach out into the world and decide that certain things are good or bad and then address them. They have to wait for cases to come and decide them. And when a case comes, it has to be presenting a question of law for the court to answer it. If a person comes to the court and they ask the court to answer something that is properly in the province of Congress, if they ask a political question, then the court has to say, I'm sorry, that's not my role. So I had, for example, a case that involved Yemeni citizens who, I'm trying to get the facts exactly right, but they had relatives. I think they were resident in the United States, and they had relatives in Yemen, a war-torn area. This is a few years ago, and they came to the court, me, asking if I could direct the administration to extract their relatives from Yemen, that they wanted me to order the executive branch to send in troops and get their relatives out because it was obviously dangerous for their relatives to be in that country. And what I said in that circumstance is essentially, I don't have jurisdiction to do that because what you're asking me to do is a political question. That the question of when and where troops can be sent and who can be extracted from foreign governments belongs with the executive branch. And so you have to ask them. And so I said I have no jurisdiction. That's a political question doctrine, and it's well established in our law.
Yesterday, in response to a question from Senator Durbin, you said that as a judge, in every case, to stay in your lane. You also described the text of law as a constraint on your authority. But in several cases, I'll list Make the Road New York, AFL-CI versus Trump, Watervale Marine Companies, and others, the D.C. Circuit reversed your decision or criticized your reasoning for failing to follow a clear and unambiguous text. Why didn't the clear text of the law constrain your authority in these cases?
Thank you, Senator. You mentioned 3 cases. Certainly with respect to the second one, the DC Circuit didn't say that the text was clear. And in fact, that's what happens in cases, that judges at the trial level do their best to make interpretations. In that case, it involved a channeling provision. This is AFG versus Trump. It involved a provision, a statute that was designed to channel the judicial authority into an agency. And I interpreted the statute, and I thought that the arguments that were being made, the claim intended to channel. And I went through the analysis, and I explained my reasoning as to why I thought I still had jurisdiction, and I went on to address the merits, which is the duty of the judge if they determine they do have jurisdiction. The DC Circuit disagreed. They wrote an opinion that interpreted the statute differently with respect to those claims, but it was a case of first impression as to what those claims meant and whether they were supposed to be channeled or not, and that happens. District judges do their best, and sometimes the Court of Appeals and the Supreme Court haven't spoken to the issue, and the parties disagree. In Make the Road, I explained that what I was attempting to do in light of Congress's enactments, not only the particular immigration provision, but also the Administrative Procedure Act, was reconcile the statutes of Congress, which is something that the courts also are supposed to do. That there are statutory interpretation canons that make clear that courts are supposed to understand that Congress intends for its statutes to work together. And to the extent that you are interpreting and the claim is made that allows you to do that, that's the sort of way in which interpretation is done. I can go through my actual analysis. I did it yesterday as we talked, but there was a good faith disagreement between me and the Court of Appeals, which gets to decide as to what the language meant and whether or not Congress actually intended to exclude the APA using that language under those circumstances.
Thank you very much.
Senator Leahy?
Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions, and I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they said they realized that a lot of the questions that were lobbed at you had nothing at all to do with your qualities as being on the Supreme Court, but were some members unfortunately aiming for what a soundbite that they might be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation on Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to conflate a nominee's past representation with their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters.
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people, people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor, and especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won, it usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, but unfortunately do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have three branches in our federal system, and the legislative branch has certain powers and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe, decide, and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling, that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, to nominated and hopefully confirmed.
Well, I agree with you. I've certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act when we've updated it a number of years. Senator Cornyn and I have been the key sponsors of legislation joined by Senator Grassley and Senator Durbin and others to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. You will become a member of the U.S. Supreme Court.
Thank you, Senator. The value of public confidence, which I was just discussing, I think, is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions. Rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you had talked about your clerking for justice prior, how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, who have been here throughout this, and what it would have meant to your grandparents. You said you were the leader of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You patient. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats, because they're thinking it should be your legal thoughts. And so I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day, in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. Being here, I think, is about, at some level, is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here. The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers, and I appreciate and yield back.
Thank you, Senator Leahy. Let's take a break for about 15 minutes.
Thank you.
Thank you very much, Judge.
Okay, so as we go into a 15-minute break, which will probably be about 25 minutes, let's see what we can do here to fill up the time a little bit, and then we'll get back to their broadcast of nothing, of nothing. Yeah, of nothing. as you see all that going on. Let's see. I pulled up a couple of things here. Josh Hawley, Senator Josh Hawley out of Missouri, apparently ripped into Kenji, Judge Jackson, that is, what I'm seeing here. So let's see what that has to show. CNN actually broadcast this. And Dan Bongino made some comments. So I'm not going to espouse Bongino. I'm just going to see what this thing is. And we'll see what happens from here. Let me bring this over here so you can see what's going on. And here we go.
Well, let's keep talking about this case. You also said to this individual who is an adult, tried as an adult, 18 years old, you also said to him, besides saying that you thought his victims were his peers, you also said there's no reason to think that you are a pedophile. And then you went on to say, again, that's another reason why you weren't going to give him, you're only going to give him 3 months because you had judged that he wasn't a pedophile. And then you said, and this is something I really need your help understanding, then you apologized to him. And I just have to tell you, I can't quite figure this out. You said to him, this is a truly difficult situation. I appreciate that your family's in the audience. I feel so sorry for them and for you and for the anguish this has caused all of you. I feel terrible about the collateral consequences of this conviction.
Okay. That was interesting. Now we go down a little bit further. We got another one. Let's see. Marsha Blackburn, Senator Marsha Blackburn. Let's see what she has to say here. Come on, computer. Come on. My computer is so slow lately. Of course, my internet is a lot slower than what I'm used to. Let's see if there's video here. No video? Okay. So what we got is a report out of OAN. And this is Marsha Blackburn going on CRT and basic biology. Judge Jackson says she cannot define the term woman. Really? Really? You can't define the term woman? Okay, let's see what it says here. Blackburn probed the judge about hot button issues, including efforts to ban biological male students from playing in female terms. However, when Jackson was asked her to define the word woman, the judge said she was not a biologist. Really? Oh, wait a minute, here we go.
Can you provide a definition for the word woman?
Can I provide a definition? No,
Yeah,
I can't.
you can't?
Not in
Okay.
this context.
So you
I'm not a
believe the meaning
biologist.
of the word woman is so unclear and controversial that you can't give me a definition?
Wow. Blackburn went on to say Jackson's inability to give a straight answer about something as fundamental as basic biology points to a much larger issue. Joe Biden's nominee also went toe-to-toe with another GOP lawmaker over critical race theory. Senator Cruz grilled the Supreme Court nominee on her association with the movement. Jackson says she serves on the board of trustees for an elite Georgetown day school, which Cruz said has a curriculum that is filled and overflowing with CRT. Uh, Cruz brought out several profs, singling out one of the books titled Anti-Racist Baby, which argues babies are taught to be racist. Cruz asked Jackson if she agreed with the book, and after a long pause, she said equality and justice is at the core of the school's mission. Uh,
Well, and I'll note that the board is chaired by Professor Fairfax, your college roommate who introduced you yesterday. So the two of you serve on the board together. Another book that is on the summer reading for 3rd through 5th grade is a book called Stamp for Kids, again by Ibram Kendi. I read the entirety of the book, and I will say it is an astonishing book. On page 33, it asks the question, can we send white people back to Europe? That's on 33. That's what's being given to 8 and 9 years old. It also, on page 115, says the idea that we should pretend not to see racism is connected to the idea that we should pretend not to see color. It's called color blindness. Skipping ahead, here's what's wrong with this. It's ridiculous. Skin color is something we all absolutely see. Skipping ahead, so to pretend not to see color is pretty convenient if you don't actually want to stamp out racism in the first place. Now, what this book argues for is the exact opposite of what Dr. King spoke about on the floor of the Lincoln Memorial. And are you comfortable with these ideas being taught to children as young as 4 in respect to the first book, as young as 8 and 9 in respect to the second book?
Senator, I have not reviewed any of those books, any of those ideas. They don't come up in my work as a judge, which I'm respectfully here to address. In my work as a judge, which is evidenced from my near decade on the bench.
so she didn't want to reply to it. Really, really. She only wanted to talk about her judge and her rulings there instead of the fact that she is on a board that, according to this article, points out that the school's website indicates that the Board of Trustees is, in fact, involved with executing their anti-racism action plan. Senator also asked her about the 1619 Project, which recasts the nation's founding as the year when enslaved Africans first arrived in the colonies. She says she never studied critical race theory, nor has it ever come up in her work. But he cited a 2015 speech made by Jackson where she explicitly talks about the theory as a judge. Yes, yes, yes.
As I read your speech at the University of Michigan Law School, however, there was a portion that surprised me. And in particular, in that speech, you referenced the work of, quote, acclaimed investigative journalist Nicole Hannah-Jones, and her, and again, this is a quote from the speech, provocative thesis that America was born in, provocative thesis that the America that was born in 1776 was not the perfect union that it purported to be. And indeed, Ms. Hannah-Jones, in her 1619 projects, describes the central thesis of the 1619 Project, which the New York Times laid out as a revisionist look of history, revising American history. And Ms. Hannah-Jones described her central thesis as, quote, one of the primary reasons the colonists decided to declare independence was because they wanted to protect the institution of slavery. Now, that claim is a highly contested historical claim. Do you agree with Ms. Hannah-Jones that one of the primary reasons the colonists decided to declare independence is because they wanted to protect the institution of slavery?
Whoa, and we all know that's not true. We all know that's not true. Oh boy. No, the colonists did not want to protect slavery. Matter of fact, some of the colonists were against slavery. Some of the founding fathers were actually against slavery. They used slaves back then as we would a gas engine. And it was a different time, different theology, and we have grown past that. We have definitely grown past that. So all these people claiming 1619 and all that other good stuff, well, well, they're just wrong because we grew as a country. And matter of fact, in the 70s, we had almost started to erase racism. Yeah, in the 70s, we had almost started to erase it. We had it almost erased. And then we had Obama. And everything went back to everything is racist. Blacks wanted more power. Blacks wanted restitution uh, for stuff that they never even did, or we never even did. They've got the whole thing wrong. We were doing good up until a point, and then, bam, they ejected it back in. Oh, not fun, not fun, not fun. I was always taught, and I grew up in the 60s and 70s, that you judge a person not by his color, but by his deeds. Really simple, really simple. Let's see. Dow is down 249, 250. Standard & Poor's is down. Nasdaq is down. Russell 2K is down. So, yeah, it's a Wednesday. Crude oil is up to $115 a barrel. Ugh. Gold is up to 1937. Actually, that's down because it was over 2,000. Silver is up. Yeah. So that's a quick look at the market. Hearing should be continuing on in just a couple minutes. I'm sorry if I get some stop action uh, on the feed. My computer is a little slow and I've got a lot going on. I'm trying to take it down to just what I need, and sometimes that doesn't work. So we'll keep going with the hearing and seeing if we can get this. Get this. Come on, come on. Oh, I gotta press play. There we go. All right, so I'll send you back to the hearing, which is just still in recess for another couple minutes, probably another 5 minutes or so, because you know it never starts after 15 minutes. It's usually 20, 25 minutes. And thank you for tuning in to Who Cares News Network. I did think this was important that we hear this. I don't know who else is broadcasting it, but for now, I'm doing it, and we'll see how it goes. How's that sound, folks? And if you noticed, the judge was dancing around questions and never actually answering them in a lot of cases. I mean, it was ridiculous how she would just talk and dance around and never answer the question, but make you think she did. I saw a few times on that. Now, my next query would be of those cases that she um, lowered the penalty, how many were black? How many were white? That's another question that should come up with what we're seeing out of her history and what she has said. So let's see if anybody dare ask that question. And here come the judge, here come the judge.
Questioning will resume. Senator Graham.
Thank you, Mr. Chairman. Good morning, Judge.
Sorry. Good morning, Senator.
I want to comment on the last exchange. And Judge, this is not of your making, so it's really not about you. But Representative Green, who's a fine man, came up and said he thought the exchange between you and Senator Leahy at the end about the arc of time and how far we've come as a nation was powerful. I agree. And I guess here's my point I'm trying to make to the American people, to my Democratic colleagues. I wish you had that same attitude when an African-American conservative is appointed to high office in the judiciary. So what happened with Janice Rogers Brown? In 2003, she was an African-American nominee for the D.C. District Court, 54 years old, a little bit older than you, but pretty close. She was a daughter and granddaughter of sharecroppers, a childhood in Alabama under Jim Crow. She was a single mother, a member of the California Supreme Court. Instead of celebrating how far we've come, my Democratic colleagues filibustered her ascension to the D.C. Circuit Court. Because it's well known on our side that we were very much considering her to be the first African-American woman on the Supreme Court. So rather than this wonderful exchange, which was wonderful, Representative Green, where were you and others when there was a wholesale assault on her nomination? Nowhere to be found. The filibuster was used for 2 years to stop her nomination, and we eventually did the Gang of 14, of which I was a part, so that she could make it through after 2 years of waiting. This is what the current president said when he was in the Senate, Joe Biden, asking about her, Janice Rogers Brown, being on the Supreme Court. I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. That's what he said about an African-American conservative nominee by President Bush who had served 5 years on the California Supreme Court. We're not going to live in America like that any longer. To my Democratic colleagues, if you're a person of color, a woman, supported by liberals, it's pretty easy sailing. But if you're Miguel Estrada, Janice Rogers Brown, Amy Coney Barrett, on and on and on, your life gets turned upside down. You had nothing to do with that. I just make this observation that when you come up to me and talk about how moving the exchange was, I agree. And I just want to remind you there was somebody else of color, a woman of color, that was picked for the D.C. Circuit, one of the highest courts in the land, that did not meet the same fate. And those days should be over. Be allowed to vote, Judge Jackson.
Thank you, Senator. States in order to vote.
So the answer would be no.
It's not consistent with our laws, so the answer is no.
Okay, why do they do that in New York?
Senator, I'm not aware of the
Okay,
circumstances.
all right, well, that's a good answer. The answer is no. Can an unborn child feel pain at 20 weeks in the birthing process?
Senator, I don't know.
Are you aware of the fact that anesthesia is provided to the unborn child at that time period if there's an operation to save the baby's life because they can in fact feel pain? Are you aware of that?
I am not aware of that.
Well, that may come before you one day, so ask you to do. You said, see him, is that right?
That is correct, Senator.
Okay, and you look at the statute as the way it's written, and you try to apply it in its plain meaning. Is that correct?
That is correct, Senator.
Have you heard of a case called Make the Road versus McAleen?
Make the Road New York, yes.
Yeah, okay. Make the Road in New York, who are they?
Make the Road New York is a nonprofit that represents various individuals in the sort of immigration law
Right.
field.
They're a nonprofit advocacy group for immigration issues. Did you know they received large donations from the Arabella Network and from George Soros's Open Society Foundation Network?
No.
Okay, well, they did. Now, in that case,
The issue in that case was a challenge to a change in administration policy concerning expedited removal, which is a policy that Congress enacted in order to expedite certain removals in the immigration system. Ordinarily, before removal,
asylum cases do not fall in this category, right?
well,
Trust me on that, because the statute says it doesn't.
if a person who could otherwise be subject to expedited removal makes and has a credible fear of torture in their country, they can be
And can they make that claim?
determined. They can be determined
Right.
to qualify for regular removal rather than
Right.
expedited removal.
So expedited removal is a creature of Congress, folks. And if you've been here 2 years or less, the statute, the statute, I'm sorry, the statute. The statute would allow the administration in office to have expedited removal, avoiding a lot of the hurdles that would exist otherwise for people here 2 years or less. So in the Obama, even Bush years, they did not look at it in terms of applying it to everybody. Some people coming by air got expedited removal, others didn't. The Trump administration decided to use the authority given to it by Congress to remove all eligible cases 2 years or less under the expedited removal statute. Is that a fair summary?
Well, Senator, I would say it differently.
We'll say it differently.
All right. The statute that you've put up indicates that Congress is giving the department, it says the Attorney General, but now it's the department,
Right.
the ability to determine what category of aliens.
If you've 2 years or less.
Yeah, but importantly, the authority it was not Congress saying 2 years or less. What Congress said is you, agency, have the authority to determine what category of persons who have been here between 0 and 24 months.
Which is
should
2
be.
years, yeah.
No, but forgive me,
So-
Senator, what I'm trying to explain is that the authority given to the agency was to determine what
They
length of
had
time.
discretion to make that
What
decision.
length of time? It was not the authority to deport everyone who's been here for 24 months. It was the authority to determine what length of time a person has to be here in order to be subjected to expedited removal.
Here's what the statute said. The Attorney General, which is actually the DHS Secretary, may apply clauses 1 and 2 of this subparagraph to any and all aliens described in subclass 2 as designated by the Attorney General, actually DHS. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. Now, I've been in this business for quite a while. What the Trump administration did was to use the discretion given to it by statute in a way different than prior administrations. This advocacy group, the Arabella-supported advocacy group, tried to strike it down. You rule for them. Here's what the D.C. Circuit Court said about your ruling. There could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expanded removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. To those of us in the law writing business, I don't know how you could tell a judge more clearly that the administration, the agency in question, has discretion to do certain things within the statute. So this is an example to me, and you may not agree, where the plain language of the statute was completely wiped out by you. You reached a conclusion because you disagree with the Trump administration, and the D.C. Circuit Court of Appeals said, as I've quoted just a minute ago, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within the statutory bounds to the Secretary's independent judgment. That, to me, is Exhibit A of activism. Let's go back to the child pornography cases.
Senator, would you allow me to?
Yes, please.
Thank you. The statute and the circumstances that you reference are accurate insofar as that is what the statute says. It's not all of it. It doesn't describe the designation process that I was trying to articulate. And it doesn't address the fact that Congress has another statute that is presumptively applied in agency cases to tell agencies how to exercise discretion. There's also DC Circuit case law that says that in addition to having that procedural statute be presumptive, even very clear designations of authority to an agency may still be subject to Congress's other directions regarding how to exercise the discretion.
That argument fell on deaf ears.
Understood. That's our appellate process.
I've got other things I want to talk about. You've given an explanation, but it didn't work. The DC Circuit Court said there could hardly be a more definitive expression of congressional intent. This is good as it gets. There's no way to write a statute saying discretion lies in an agency. It's sole. It's non-reviewable. So you're not convincing me that
With
this was
respect,
anything
Senator.
other than activism, and we can talk about it all day long, but I agree with the DC court. This, to me, is an example, Exhibit A, of a judge ignoring limitations placed in the law by Congress to get a result they wanted. Child pornography. I have no doubt that you find child pornography disgusting as the rest of America. You're a mother. You seem to be a very nice person. Are you aware of how many images are out there on the internet involving children and sexually compromising situations?
Senator, I'm not aware of the numbers, but I've seen the images in my
and they are disgusting,
role
right? Well, let me
as
tell
a
you the
judge.
numbers. In 2021, the National Center for Missing and Exploited Children Cyber Tip Line received 29.3 million reports of apparent child sexual exploitation containing 85 million images, videos, and other files. That's in 2021. It's up. In 2019, it was less. So there's an epidemic of this on the internet. That if you go out on the internet, there are millions of pictures of kids being abused. When it comes to sentencing child pornography possession cases, do you routinely discount the fact that a computer was used?
Thank you, Senator, for allowing me to address this concern. The guidelines related to child pornography were drafted at a time in which a computer was not used for the majority, if not almost all, of these kinds of horrible crimes. The guidelines have enhancements in them.
In two areas that you said you disagree. What are those two areas?
At the time that the guidelines were drafted, it was an aggravating factor, a substantial aggravating factor, to use a computer in order to distribute and disseminate the images because the ordinary crime was not committed by computer. So the
Would you now agree with me that computers are sort of the venue of choice for child pornographer people?
Yes, Senator.
Okay, so here's my point. If you believe, as I do, the computer has created a bigger demand, there are more photos out there because of the internet, more websites exposing this garbage, wouldn't you want to deter people from going down that road?
Senator, this crime is among the most difficult.
No, answer my question. Wouldn't you want to deter people from going down the road of using the computer that allows these people to have access to millions of photos because of the technology? I want those people deterred. So if
Senator,
you're listening to my voice today and you're on a computer looking at child pornography and you get caught, I hope your sentence is enhanced because the computer and the internet is feeding the beast here. That all these images out there are going to be more over time because people use computers. Now, didn't you also say that the number of images should not be considered as a sentence enhancement?
Senator, with respect to the computer, one of the most effective deterrents is one that I imposed in every case and that judges across the country impose in every case, which is substantial supervision. Any of these
Wait a minute,
defendants.
Judge. You think it is a bigger deterrent to take somebody who's on a computer looking at sexual images of children in the most disgusting way is to supervise their computer habits versus putting them in jail?
No, Senator, I didn't say versus.
That's exactly what you said. I think the best way to deter people from getting on a computer and viewing thousands and hundreds and over time, maybe millions, the population as a whole, of children being exploited and abused every time somebody clicks on is to put their ass in jail, not supervise their computer usage.
Senator, I wasn't talking about versus.
You just said you thought it was a deterrent to supervise them. I don't think it's a deterrent. I think the deterrent is putting them in jail.
Senator,
Does
would you let
sentencing
her
have
respond?
a deterrent component?
Senator, would you let her respond?
Yes. Does sentencing have a deterrent component?
Yes, Senator, deterrence is one of the purposes of punishment, and Congress has directed courts to consider various means of achieving deterrence. One of them, as you've said, is incarceration. Another, as I tried to mention, was substantial periods of supervision once the person.
So if I could may ask you, in your view, it's more of a deterrent to have somebody substantially supervised in terms of their computer use who's looking at child pornography than it is to put them in jail?
Senator, I'm not saying it's more or
That's
less.
exactly what you're saying.
What I'd like to point out is that if we're going to, let me say it this way. Congress has authorized courts to use a number of different means to achieve the purposes of punishment.
And one of them is an enhanced punishment by using a computer.
The enhancement with respect to using a computer relates to the penalty in terms of incarceration.
Boy, Lindsay
You
is
would
getting
choose
her
not to apply
confused
that in
and
these cases.
upset.
You've said that. I'll read you the quote, but you've decided not to apply the use of a computer as an enhancement. You've also said you're not going to hold the number of images that the person has looked at as a sentencing enhancement factor. Is that true?
No, Senator, it's not the number of images that the person has looked at because we don't have that information.
Well,
It is the number of images that they've either received or distributed
well,
that are.
whether we don't know if they looked at them, but you're not going to hold it against them that they received 10,000 images versus 100.
That's not what I've said, Senator.
Well, here's what you said. I've decided to apply my general policy disagreement with respect to those enhancements, at least that is the computers and the number of images. Folks, what she is saying, the reason she's always below the recommendation, I think, is because she doesn't use the enhancements available to her. She takes them off the table. And I think that's a big mistake, Judge. I think that every federal judge out there should make it harder for somebody to go on a computer and view this filth. That if you use that venue, which is the venue of choice for all these child pornography cases, that you use it against them. I think the more you download, like drugs, the more you have, the more you should go to jail. You've made a conscious decision to disregard those two enhancement sentencing factors, and I think that is a wrong way to go in terms of deterrent. To me, putting somebody in jail for using a computer is more of a deterrent than supervising their activity of watching the computer. That's just a difference that we have. I know I'm out of time, and listen, you've lived an incredible life, but here's one thing that won't happen to you as we wrap this up. How would you feel that if I'd had a letter from somebody accusing you of something, a crime or misconduct, for weeks, and I give it to Senator Durbin just before this hearing's over, and not allow you to comment on the accusation? How would you feel about that?
Senator, I'm not sure. I don't understand the context of the question.
Well, did you watch the Kavanaugh hearings?
No, sir.
Are you familiar with what happened in the Kavanaugh hearings?
Generally.
Senator, your time is.
Well, please, Mr. Chairman. So, to be honest, it's a minute and 47 seconds. She filibustered every question I had, and she has a right to give an answer, but I'm trying to make a point in 20 minutes. You were here for Kavanaugh. If she's confused about what happened, some people on the other side had an accusation against Judge Kavanaugh that during high school, he sexually assaulted somebody. And the rest is history. That was known to the people on the other side and never revealed during the meetings they had with Judge Kavanaugh. It was literally ambushed. He was ambushed. How would you feel if we did that to you?
Senator, I've appreciated the kindness that each of you has shown me to see me in your offices, to talk with me about my approach.
But my question is, what if during our 15-minute exchange, it was very pleasant? You're a very nice person. You have a lot to be proud of. I would never do that to you. If I had some information that's sketchy at best, that somehow you've done something wrong, I promise you, just from human decency, I would share it with you. I would not disclose it at the last minute of the last day of the hearing, and I've already given it to a newspaper so the whole country can read about it before you ever said a word.
Senator, she's had nothing to do with the cause.
No, but I'm asking her about
you won't even let her finish
how
your
she may
response.
feel about what y'all did.
Could we have order,
Senator, your
Mr.
time has expired, and I'm going to give her an opportunity to finally complete an answer.
So, if I could
Just
address
answer the question.
Senator, I don't have any comment on what procedures took place in this body regarding
What'd you think about
Justice
the Kavanaugh hearing?
Kavanaugh. What I'd like to answer is your points about my sentencings in child pornography cases. The point of the guidelines is to assist judges in determining what punishment to provide in cases. And there are horrible cases, but the idea is that between the range of punishment that Congress has prescribed, judges are supposed to be providing proportional punishment based on what a person has done. The sentencing scheme doesn't place everybody at the same level. The point of judging and the guidelines is to look at what has happened in a case, compare defendants to each other in terms of what they've done, and give proportional penalties based.
Mr. Chairman, this is she has said, Mr. Chairman, she does not use sentence enhancements in the area of somebody using a computer for everybody.
Can I explain why, sir?
I'm going to give the witness an opportunity to respond to you, Senator.
Finally.
At
Why?
the time that the guidelines were created for child pornography, this crime was primarily being committed by people who were literally mailing 1, 2, 5, 10, 100 photos at a time.
How's it being committed now?
Would she please
Go
let
ahead.
her complete her answer?
Go ahead.
As a result, the commission determined in the guidelines that it was a substantial aggravating factor if the facts of the case demonstrated that someone had been distributing hundreds of images. Because what that meant was, over this long, maybe it was a long period of time, they had collected one photo at a time, they had amassed it, they had potentially mailed one at a time, and that showed really aggravated, terrible conduct. I'm not saying as a baseline it's not terrible, it's all terrible. But what we're doing is we're differentiating among defendants. So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good.
I understand,
Absolutely
Senator, but
good.
what
I hope you
we're trying
are.
to do.
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of children and sexual exploitation. So you don't think that's a bad thing? I think that's a horrible
That's
thing.
not what the witness said, and she should be allowed to answer this question once and for all.
Senator, all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change, such that in 2 seconds, someone can receive or distribute thousands of images, that's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
Well,
and so what we're trying to do is be rational in our dealing with some of the most horrible kinds of behavior. This is what our justice system is about. It's about judges making determinations in meting out penalties to people who have done terrible things.
It is not rational to take the venue of choice of child pornographers, the computer that have 85 million images on it, and not consider that feeding the beast. We're trying to get people to stop this crap. So when you troll on the internet and you pull down thousands of images of children from the internet, I want you to stop that. I want people to go to jail who do that, because you're feeding the beast. We have a bill here, the Earn It Act, that would allow the victims who are on the internet over and over again to sue the media companies that provide these images. We have a fundamental differences of how you deter crime. I think the best way you deter crime when it comes to child pornography is you lower the boom on anybody who goes onto the internet and pulls out these images for their pleasure.
Senator, every person in all of these charts and documents I sent to jail because I know how serious this crime is. Every person I discussed the harm of these terrible, terrible images to the victims who are portrayed in them. I talked about what this crime does to the children who are being abused in these photos, and on the other side of their terms of imprisonment, I ensured that they were facing lengthy periods of supervision and restrictions on their computer use so they could not do this sort of thing again. That's what Congress has required of judges, and that's what I did in every case.
You always were under the recommendation of the prosecutor, many times the parole people. And to be honest with you, Judge, a 32-year-old man who sent an image of his own 10-year-old daughter, you substantially reduced the not only the guidelines, but the recommendation. And all I can say is that your view of how to deter child pornography is not my view. I think you're doing it wrong, and every judge who does what you're doing is making it easier for the children to be exploited. If you're on a computer right now looking at a kid in a sexually compromising situation and you get caught, I hope nobody gives you a break because you used the computer.
The conduct that's been described is reprehensible, and I think everyone in this room agrees. And the fact of the matter is that I'm co-sponsor of your bill, the Earn It Act, and I believe that we should be doing our job here. But part of our job, we have failed in responding to the changing circumstances that face this crime. What has it been, 15 or 16 years? She is currently not an outlier in sentencing. 70% of the federal judges face the same dilemma and wonder why Congress has failed to act and when it will act.
This is our fault?
Partially it is, Senator. To be honest with you, it is. We have to upgrade these guidelines and decide whether we're going to stick with the Supreme Court decision that they're not mandatory. Senator Feinstein.
Thank you very much, Mr. Chairman. I would like to compliment the witness. You've been answering, I think, close to 15 hours worth of questions. And I know how difficult this is and hard it is. But I just want you to say in this senator's senator's eyes, you've handled it very, very well. So
Thank you, Senator.
And I'll move on to my questions. Congress has recognized how important it is for crime victims to participate in the legal process. And one example is the Crime Victims' Rights Act, which I authored with Senator John Kyle in 2004. That law provides certain rights for victims at critical stages of the legal process. The right to be notified, to be present, to be heard, among others. And I understand that in your 8 years as a district court judge, you would carefully consider victim impact statements when imposing criminal sentences. Could you tell us a little bit about this? Crime victims in making your sentencing decisions as a judge.
Thank you, Senator. As you say, the law provides for victims to have an opportunity to address the judge, to address the court, to explain the harms that happen as a result of criminal behavior. And in the time that I was a trial judge, I found it to be a very important part of our criminal justice process because my sentencings were about handing down consequences for the behavior that defendants have. Promoting the purposes of punishment, which is what Congress has required of judges, were made clear to the defendant in every case. So I had, for example, a case involving robbery. There were two. It was a single defendant who committed two robberies, one in April and one in September, of the same small pharmacy in DuPont Circle, which is not far from here. It's a small independent pharmacy selling pharmaceuticals, and this person decided that he was going to rob the pharmacy of their oxycodone and other kinds of prescription drugs for sale. That's a sort of standard scenario that we see in the federal system, but what was so particularly egregious in this case is that this defendant was so bold in his robberies. He came in April with a gun. He held the employees hostage, essentially, forcing them to open the safe with the drugs in it at gunpoint, stole the drugs. Not masked, not hiding his identity. And this is pre-COVID, so we're not talking about having to have a mask. He was a robber, plain and simple, with no fear of people identifying him. And then, in the period between April and September, he would come back to the pharmacy. He would loiter outside on the street. This is according to the victims. They would see him looking in the window. Once or twice he came inside, looking like he was going to buy something and staring them down. And they knew who he was, and they called the police, and they weren't able to, apprehend him because he hadn't really done anything at that point. And the people who worked in the pharmacy were terrified, and they were terrified by that behavior, the menacing nature of it. By the time we get to September, he actually comes in, and they think maybe this is another time when he's just loitering, but no, he pulls out a gun, he hops over the counter, he assaults one of the people who are working there and steals the drugs again. And that time they were able to call the police in enough time for them to come and apprehend him. So at his trial, he did not try. He didn't go to trial.
You're the judge?
I'm the judge. He pled guilty to this behavior, which was well documented. There was no defense that it wasn't him. But the guidelines in the case and the statutes that applied said because he used the gun, he was supposed to get something like 7 years. And I used the victim statements to, first of all, explain to him how he had terrorized the people. Their statements said one woman said, "I can't work at the pharmacy anymore because I am so fearful that this guy will come back. It's changed my whole life." It was a whole set of really horrible circumstances that I read to him at his sentencing so that he could understand what he'd actually done. And then I sentenced him above the requirement of the law because I thought it was warranted to make clear to him that this was a terrible, terrible thing that he had done to these people. So the victim statements were really important because they explained to me and to him the consequences of his behavior, but beyond just how many drugs he stole or the fact that he used a gun. They were the real life circumstances that resulted from his behavior, and it was important for him to understand that.
I've listened to most all of this testimony, which I think now you've gone on for over 15 hours. And I just want to say that I think you have a stamina and a very good brain and a real sense of empathy has been communicated to me in these 15 hours. And I want you to know that. One of the things that I'm concerned about is that the public perception of the Supreme Court has turned increasingly negative over the last few years. A recent Pew Research survey found that 44% of adults have an unfavorable view of the Supreme Court. Less than 3 years ago, that number was 30% of adults that held that view. And I understand that as a judge on the D.C. bench, you have frequently accepted invitations to speak at public events in the hopes of giving the public more information about the judicial process and more. I think there's been a decline in the public's perception of the court. And if you are confirmed, how would you strive to improve the public's confidence in the court and its decisions?
Thank you, Senator. I think that public confidence in the court is very important. It is, it's crucial to the rule of law that the public believe in the judicial process and therefore choose to accept the rulings of the courts, not just the Supreme Court, but all of the courts. It's part of the way our process works. And I think that I have taken that to mean, in terms of my role as a judge, that outreach to the public to explain what it is that we do, to inspire, hopefully, law school students and high school students, young lawyers in law firms and elsewhere, to think about careers in the judicial branch or think about
So
careers
her
in law,
answer is to
as
what?
one of the ways that I have attempted to try
Talk to
to
people instead of
shore
doing
up public
great
confidence. And
decisions.
if I'm confirmed, I would plan to continue as best as I can to do that kind of thing, because as you say, it's very important for the public to understand the work of the court and to follow its pronouncements concerning the law.
Earlier, when you and I spoke in my office, we discussed some of the people who have mentored you throughout your career. And one of those was Judge Patty Saris. You served as a law clerk for her on the Massachusetts District Court, I believe, early in your career. And you've spoken publicly about the role she has played as a mentor in your legal career. You have described her as, quote, a consensus builder, a good listener, a careful speaker, the essence of judicial temperament, end quote. So would you share with all of the members here more about how Judge Saris's approach to judging and her mentorship shaped you and your career? If you give some of the specifics.
Yes, on her mentorship and also the mentorship of my other two judges. It's very interesting because I think I learned maybe different things from each of them. Judge Saris, who was my first clerkship, you're correct. She's serves on the District Court of Massachusetts, which is the trial level court. I learned how to look at the facts in a case from Judge Saris. That's part of what the trial court level does. We, as trial judges, develop the record in a case, take testimony, have trials, and she is extraordinary at developing a record and making sure that all of the relevant facts are used from the witnesses and considered in the context of her trial and record responsibilities. And so that, I think, is something that I learned from her in terms of the law, and her warmth and care for her law clerks meant that she has been a lifelong mentor to me. And ironically, she became the chair of the Sentencing Commission after I had been on the Sentencing Commission. So we worked together later in my career. So I often use that story to tell young people, you know, you never know what's going to happen. Someone who you worked for at some point might be your colleague down the line.
Well, let me just one more. You've handled a large number of cases during your career, both as an advocate and a judge. As an advocate, you've worked on a very wide variety of cases, from work for corporate clients during your time in private practice to your work for low-income clients during your service as a federal public defender. And during your 9 years as a federal judge, you've written nearly 600 opinions. I think that's really quite a sterling record. And I imagine that some of the cases have really stuck with you. And so I would like you, if you can, to talk a little bit about some of the cases, maybe one or two, that you've had that have made a deep impression and have really enabled you to progress as you have.
Thank you, Senator. Well, as you say, I have handled a lot of cases in my time, nearly decade on the bench, and you learn something in almost every case in some respect. If you're doing your job right and you're looking into all of the issues. I think there might be, I'd mention one from sort of a few years into my service as a trial judge. I handled a case, Yakai versus Napper. And the case involved trademark infringement. And you would ordinarily think that trademark infringement charges are dry and technical. And what I learned from this case is that even areas of the law that you might think apply only to businesses impact real people at times. So this case involved a small community, a cultural community of people who believe in vegan lifestyles. They call themselves the African Hebrew Israelites, but it's not a religious community. It's a cultural community around healthy living. And they have created a restaurant and a series of restaurants here in the Washington, D.C. area with menus involving really, I'm told, terrific vegan foods. And in this community, there was a member who was the one who created the recipes and who was responsible for the restaurant. The whole community had other aspects to it. He ended up falling out with the community, and the dispute involved his actions essentially taking over the restaurant and reopening it by himself using the same name. The restaurant was called Everlasting Life, which was a important phrase for this community. And he essentially ejected the other members because he was the leaseholder, or he had signed the lease on behalf of the community. And he kicked them out for a day, and then he reopened the restaurant using the same name. And so the question was, under the Lanham Act, which is the statute for trademark violations, the question is whether there is a potential for confusion in that sort of circumstance. But ordinarily, I see Senator Coons nodding, ordinarily, when you have a trademark infringement, you're talking about two different businesses who have very similar products. And the question is, are they similar enough to cause confusion? Because the idea of the law is that people should be able to have products that are identified with them, and you shouldn't be confused. And in this case, we had a bench trial about it, but it was pretty clear. I was the fact finder as the judge. It was pretty clear that when you open the same business with the same name, using the same recipes and food, that you have created this kind of problem that is a trademark violation. But what was so interesting to me about the case, in addition to the fact that I got to be the fact finder, it was a bench trial, was that we had witnesses come in who testified about the circumstances. This was a very small community, and they all knew each other, and the testimony about what it meant to them to have one of their members ejected in this way and then have him turn on them was very, very moving in the courtroom. So even though we were talking about this kind of arcane area of the law, it was real circumstances that were happening.
Well, stop for a minute.
Yes.
I think you're a very important addition to the court. And what I'm trying to fathom out from the hearing is, what kind of judge will she be? How will we look at her in 5 or 6 years? And so what I really want to ascertain is what kind of a judge you will be. What will be the principles you hold dear, and how will you function in this capacity? If you could just answer that one question. I've been waiting for it
Yes.
for about 15 hours, so I'd appreciate it. Thank you.
Well, I would hope to be the kind of judge that I have been during this last decade. I have been the kind of judge who understands that it's my responsibility to rule neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter, facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress if it's a statute, or to adhere to my own. I've been saying stay in my lane, to not exert my authority beyond what the Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and ruling consistent with Article 3.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Cornyn?
Good afternoon, Judge. I understand I'm the last one, maybe before lunch, so if your blood sugar is getting a little low, you can think about having a little break. But just because the chairman keeps bringing this topic up, let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Oh, Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding and in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them. It depends on the circumstances.
It depends on the circumstances.
Yes.
So you put this in the same category as defining what a biological woman is?
No,
You're really not sure.
I didn't say I wasn't sure. I said it depends on the circumstances.
So you are sure?
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
I just don't think that's credible, Judge. Let me ask you another question. You talk about the public confidence in the courts, in our institutions, which I agree are very, very important, that the public has confidence in our judiciary. Would you agree with me that to the extent that people perceive that judges, unelected, lifetime tenured judges, are making policy pronouncements or political decisions, that it undermines public confidence?
I do.
Thank you. Yesterday, we talked a little bit about precedent. And I know Senator Feinstein, as she does in these hearings, talked about super precedent, and in particular, Roe versus Wade. And I want to talk a little bit about that. But first, let me just ask you, do you think there's any good reason for the Supreme Court not to overrule a previous decision when they've concluded that that decision was wrong?
Thank you, Senator. Again, it's hard for me to answer that question in the abstract. What I'll say is that the Supreme Court has laid out factors beyond just the precedent being wrong as a reason to overturn it.
Well, we talked a little bit about this yesterday. The Supreme Court revisited the issue of separate but equal, which was the law, the constitutional interpretation of the Supreme Court under Plessy versus Ferguson, and overruled that precedent because it concluded it was wrong, right?
I haven't looked carefully at whether all of the different factors that the Supreme Court now uses to overturn were discussed in the opinion, but now the Supreme Court's precedent is to overturn on the basis of a number of different factors and not just whether or not it's wrong.
So are you suggesting that the Supreme Court could not or would not overrule a precedent that it determined was wrongly decided?
No, I'm suggesting that the Supreme Court's case law indicates that it looks at multiple factors.
No, I understand. You go through the stare decisis analysis, right?
Yes.
But if it's wrong, that's one of the factors that you consider, right?
Yes, but it's not the only one.
So are you suggesting that there may be circumstances under which the court determines its previous decision is wrong, but it will not overrule it?
The fact that there are multiple factors indicates that the court looks at more than whether or not it's wrong.
Okay, so so you would say, if I'm interpreting you correctly, that if the court concludes its previous decision is wrong, it won't necessarily overrule that. It applies a multi-point analysis.
Yes, I think that's
Okay.
accurate.
Back when Roe versus Wade was decided in 1973, generally speaking, the court said that the states may not limit access to abortion pre-viability, but post-viability, there could be some restriction on the right to abortion. Is that generally the?
As a general matter, yes.
Okay, thank you. Okay. Well, and then I think it's since 1973, the question of viability has risen again, what that actually means, because now viability was around 28 weeks. That is, the fetus could live outside the womb. But today, because of the advances in medical science, the fetus can live outside the womb after about 23 weeks. Is that your understanding?
Senator, I haven't studied this, so I don't know a number of weeks in the way that you're saying.
Well, let's talk a little bit about viability. The line that was drawn for pre-viability and post-viability analysis by the courts. What does viability mean when it comes to an unborn child, in your understanding?
Senator, I hesitate to speculate. I know that it is a point in time that the court has identified in terms of when the standards that apply to regulation of the right.
Justice Brennan, at a later point in his career on the Supreme Court, admitted that the viability line was an arbitrary line. Do you agree with him?
Senator, I'm not able to comment on viability. There's a case pending in the Supreme Court right now concerning the issues.
I'm asking you about previous decisions, but I hear you. No one suggests that a 20-week-old fetus can live independently outside the mother's womb. Do they?
I don't know.
I mean, the child will need to be fed or sheltered and all the other essentials to sustain human life. So there's no suggestion that after 20 weeks that a child can live independently, correct?
Senator, I'm not a biologist. I haven't studied this. I don't know.
You don't know whether an unborn child could live outside the womb at 20 weeks gestation?
What I know is that the Supreme Court has tests and standards that it's applied when it evaluates regulation of the right of a woman to terminate their pregnancy. They have the court has announced that there is a right to terminate up to the point of viability, subject to the framework in Roe and Casey, and there's a pending case right now that is addressing these issues.
The Constitution doesn't mention the word abortion, correct?
That's correct.
Just like it doesn't mention the word marriage, correct?
That is correct.
And so as you and I discussed, perhaps ad nauseum yesterday, when we were talking about substantive due process, this is one of those unenumerated rights that the court has created, court-made doctrine or law, in creating a constitutional right, even though it's not explicitly mentioned in the Constitution itself. Correct?
The court has interpreted the due process clause of the 14th Amendment to include.
Right, we talked about substantive due process yesterday, and that's what this is, right? The Supreme Court cases that deal with the right of abortion is a result of substantive due process analysis like you and I talked about yesterday.
Yes.
Okay. In the, you remember when you were confirmed for the Court of Appeals, in that process, we had a hearing, and then we sent you questions for the record, what we call QFRs around here.
Yes.
And one of those, question number 10, was, does the Constitution protect rights that are not expressly enumerated in the Constitution? As part of your answer, you mentioned Roe versus Wade and Planned Parenthood versus Casey, and you said this, and I'll quote, "They articulate a limited right to terminate a pregnancy." What is the limitation that you understand that was pronounced in Roe versus Wade and Casey when it comes to a right to terminate an abortion? What are the limitations under current law?
Under current law, as I understand it, there are limitations in so far as there can be regulation of that right pre-viability unless the regulation imposes an undue burden on the exercise of the right. And there can be regulation after viability, as long as there's exception for the health and I think maybe life of the mother. So it's the limitations are about whether and to what extent the government can regulate the right.
Is it your understanding under the current precedent of the Supreme Court that there is a right to abortion up to and including the time of delivery of the child?
Senator, I don't know, actually. I mean, the Supreme Court in every case is looking at individual regulations of the government related to individual rights. And I am not aware of the court having made a pronouncement about whether or not regulation can extend all the way up until birth. I'm just not aware of that. And that it's because the court is looking at individual cases and making its rulings in the context of individual cases and not making sort of pronouncements in general.
So you are suggesting that in some individual case, the right to abortion could extend through the entire pregnancy up until the time the child is delivered?
No, Senator, I'm suggesting that I'm not aware of any case that's handled the issue.
You told us that you think that you believe Roe versus Wade and Casey are precedents, and we talked a little bit about some of the questions about whether it's a super precedent and the like. Are you familiar with the Supreme Court's decision in the Heller case?
I am.
And that was a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment, correct?
Yes.
Is that a precedent of the court?
It is.
And you would respect that precedent?
Yes, Senator. All precedents of the Supreme Court have to be respected.
Is it equivalent in terms of its precedence to Roe versus Wade, or would you evaluate it differently?
I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis.
I agree with you. That's why it kind of blows my mind when people talk about super precedents, as if somehow one precedent was different in terms of its significance or priority under the Constitution than others. In the short period of time I have remaining, let me just revisit with you some of the questions we talked about yesterday with regard to free exercise of religion. And of course, that's recognized explicitly under the United States Constitution, the First Amendment, correct?
Yes.
Okay. Are you familiar with the cases that have been litigated before the Supreme Court of the United States involving the Little Sisters of the Poor with regard to the Affordable Care Act mandate on contraception coverage?
Yes.
Now, the Little Sisters of the Poor are a benevolent group of nuns. I think there are about 300 of them that take care of elderly and infirm individuals. And of course, as a matter of their religious beliefs, as documented in the court's opinions, they don't believe in either contraception or abortion. Do you agree with that?
I believe that was described in the case that you're talking about.
I think that's right, too.
Yes.
Yeah. And so when the Affordable Care Act mandated that every health insurance policy contain coverage for contraception or chemically induced abortions, they objected and said that this violated their conscience and their free exercise of religion rights under the First Amendment, right?
I believe so, yes.
Well, after the Obama administration, during the Trump administration expanded the regulations to allow not only churches, but also religious organizations like the Little Sisters of the Poor a waiver from that contraception and abortion-inducing drug mandate. Do you recall that?
Yes.
Are you familiar with the fact that President Biden has said he would restore the previous regulation and that was promulgated under the Obama administration and exclude organizations like the Little Sisters of the Poor from that waiver potential for abortion drugs or contraception coverage?
I am not aware of that, Senator.
Well, I guess what all this boils down to, Congress passed a bill called the Religious Freedom Restoration Act, which tried to make sure that people's sincerely held religious beliefs could be accommodated under their First Amendment rights, as opposed to Congress mandating things that would violate their conscience and violate their religious beliefs. Do you agree with me that it's important to accommodate the sincerely held religious beliefs of all Americans when it comes to legislation that the Congress may pass?
Thank you, Senator. Religious freedom is a core foundational constitutional right. It's in the First Amendment of the Constitution and reflects the Founding Fathers' understanding of this country as being one that is based on, in large part, the idea of pluralism, the idea that people can come and have sincerely held religious beliefs and practice them without persecution. That's part of the foundation of our government and the amendment that you're discussing. And as a result, that right is protected in many ways. You mentioned the Religious Freedom Restoration Act.
Right.
Congress has enacted a statute that, when it comes to federal regulation, if there's a substantial burden placed on religion, then the strict scrutiny standard applies.
I agree. I have 1 minute, so I have one more
Yes.
question. I agree with what you just said.
Yes.
So since I have asked this question or made this point of some of your predecessors who sat in the same chair and expressed my concern about some of the court's establishment law, establishment jurisprudence, I don't want to leave you out of that concern. When I was Attorney General of Texas, I had a chance to argue a case in front of the United States Supreme Court and called Santa Fe Independent School District versus Doe. This was a lawsuit brought by the ACLU, which sought to enjoin or prevent a student-led prayer before football games at the Santa Fe Independent School District right outside of Houston. In the end, 5 judges said that that violated the Establishment Clause of the Constitution, causing Chief Justice Rehnquist to write in his dissent that the Constitution mandates neutrality toward religion, not hostility, but that the court's decision evidenced hostility towards religious expression, leaving me to conclude that the public square, we can talk about everything from violence to misogyny to sex, you name it, but we can't talk about religious, sincerely held religious beliefs. I would just footnote that for you and plant the seed for what it's worth. Thank you very much.
Thank you.
Thank you, Senator Cornyn. Welcome to Majority Leader Schumer. Glad you're with us. And he would report, if he could, that we have a challenge to finish our hearing today at a time when we can go to the floor for a series of votes, which will end the day. So we want to stick to the schedule as much as we possibly can. I will just say that Senator Cornyn's suggestion of lunch was aspirational.
Okay.
It was an unenumerated right.
You're in charge of the agenda, Mr. Chairman.
What we had hoped to do was to take 3 more senators before we have an actual lunch.
Oh.
But it's up to you. Is that all right?
Oh, whatever you want to do. I'm open in here, happy to answer whoever would like to ask me a question.
Thank you. I appreciate that. Senator Whitehouse.
Thank you, Chairman. Judge Jackson, you can relax for a bit. I voted for you for the D.C. Circuit, and when you appeared as a potential nominee, we started doing work looking at your record and your story. We met with the president to discuss his process and his goals. When your nomination was announced, we obviously brought the work on your record more into focus, and now I've had the chance over, 15, 16 hours to see your performance in this hearing, which I think sets the gold standard for patience and courtesy. So I'm prepared to not only support you, but to let you know that I will be very proud and very honored and very excited to support you. There are 2 things that have come up during the course of the hearing, Mr. Chairman, that I'd like to take my time to have a chance to respond to. And the first has been a question, I've been through a bunch of these now. I don't think I've ever heard it come up so much. Questions about the nominee's judicial philosophy. I didn't know you needed to have one. I actually thought that when you're dealing with the Constitution, your oath of office, the constitutional precedents, and the Constitution itself kind of gave you your guide path. And when you're construing statutes, the law and the conventions of the language and your logic gave you that path. So the fact that Judge Jackson has said, I don't have a judicial philosophy, I've got a judicial methodology, doesn't bother me a bit. In fact, it kind of bothers me the expectation that a nominee to the Supreme Court should have a judicial philosophy. Because a judicial philosophy can be a screen for a predisposition that judges, frankly, should not have, but that folks in powers and interests influential in the process may very well want them to have. So You know, when I think about judicial philosophy, one of them that's come up a lot has been originalism. And one of the problems with the judicial philosophy is occasional adherence, selective adherence, which in my mind makes it less of a judicial philosophy and more of a doctrine of convenience to be trotted out when it helps the people that you want to help. And originalism strikes me as being that kind of a doctrine. And the place where I think we have the biggest gap between philosophy and practice in all of this has been with respect to what I've witnessed with respect to corporate power in our democracy in the time that I have been in the Senate. If you go back to the founding days, there was no expectation that corporations would have any role in American democracy. Nil. Doesn't turn up in the constitutional debates, doesn't turn up in the arguments leading up to the approval of the Constitution. It's only when corporations became big and powerful many decades later that they began to intrude in our politics, and they corrupted our politics in a terrible way, history shows. And that led to the movement by muckrakers, whose probably best leader was Teddy Roosevelt, to knock down the grasping political power of corporations and rein them in. And we had some real victories at that time, but ambitions of those of great wealth and power do not go away, and they have continually crept forward. It's an age-old story. And right now, we have corporate power controlling this Congress in a way that is really remarkable. We have a complete inability to address the climate havoc that fossil fuel emissions are creating because half of Congress has been disarmed and disabled by political influence of the fossil fuel industry. We can't even have a reasonable and sensible discussion on it because the power of that industry is so great. And we've seen that manifested first with Republican justices on the Supreme Court letting corporations into politics. That was an interesting invention. And then once they were in, they let them spend money in politics. And then once they let them spend money in politics, they let them spend unlimited money in politics. And now we are looking at a court whose majority is in the process of building a right for corporations, the biggest and most powerful corporations that we have, to not only get into politics, spend money in politics, and spend unlimited money in politics, but to spend unlimited money in politics anonymously, to hide from the real voters, the we the people, who they actually are when they're intervening in our politics, and to play this game through phony front groups with ridiculous names. Rhode Islanders for peace and puppies and prosperity, you know, sort of the quality of the name that's involved. So let's not get too excited about judicial philosophy if it's nothing more than a screen for a predisposition that will benefit certain players in the arena. And let's certainly not take judicial philosophy too seriously when it evaporates in the face of the interests that have pushed the philosophy. And I think originalism qualifies that way, and I just wanted to say that. I don't think you have to have a judicial philosophy. I think you have to have integrity. I think you have to have a judicial temperament. But a philosophy? Where has that come from? The second thing I want to say has to do with the question of court packing and the integrity of the court. And I have a position on this, and I just want to say it so it's all clear and nobody's reading things into it that I don't believe, and I've had a chance to make my point here. And that is that court packing can be done by adding new seats to the court. I haven't proposed that. I think there's only one member in the Senate that has proposed that. It's gotten a lot of attention here, but I don't think it's been proposed here. But you can also pack a court by picking the justices. And in fact, there is a long, unpleasant American tradition of agencies being taken over by virtue of picking the members. It's called agency capture or regulatory capture. It goes back a long way. There is an abundant literature, both in economics and in administrative law, about capture. And there's nothing that makes a court immune to capture. That is why, when I talked about this in my initial remarks, I said that the folks that have tried to capture the court have treated it no different than a 19th century railroad commission, because they were legendary for having been captured by picking the members who would rule for the railroad. And there are many others. Go back to MMS in the Gulf oil explosion. So that is my concern. My concern is that the picking of the justices has been handed to special interests. And we know that's the case because, as I showed yesterday, everybody involved admitted it. The President of the United States said so. The co-founder of the Federalist Society said so. A former chairman of this committee said so. And the President's legal counsel said so. And what happened in that process by which the justices were picked over at the Federalist Society? We don't know. There wasn't a poll that was taken of Federalist Society members saying, you know, give us your recommendations. I don't know that there was any meeting of the board. Let's take this up. Let's go through a proper agenda. What appears to have happened is that people went into a back room and there was wheeling and dealing, and millions of dark money dollars flowed into the Federalist Society during this period. And what came out were names. And those went straight to the president and straight to here. But the picking appears to have been done in the confines of a private organization by anonymous special interests. There is no country in the world that does that by way of how you pick judges. If we went to some banana republic to try to educate them in democracy, and that was the way they picked their judges, we'd have a lot to say about it. But that is the way that recent justices have been picked. Court packing by court picking. And deputizing this to the Federalist Society is very unusual. Them having no process, no public process for implementing that deputization is very unusual. The provenance of these mysterious lists that were produced and how people got on and off them, that is very unusual, unprecedented in our history. And it's surrounded by lots and lots of dark money. $400 million, I think, is a lot of anonymous money that has been chronicled being spent to control who gets put on the court. And controlling who gets put on a governmental body is how you capture a governmental body, and a captured governmental body is a wrong thing, whether it's a railroad commission or the United States Supreme Court. There is in that method of judicial selection not just the prospect of impropriety, but indeed the likelihood of impropriety. If it's pay to play and checks for millions anonymously delivered will get you into the room to decide who is going to be on the Supreme Court, we got a problem. And that's what happened. And the thing that makes it even worse, in my view, is that as you pursue this and play it out, you see the decisions of the court line up in an astonishingly clear pattern with the interests of big Republican dark money donors. That is my concern. That, I think, is a legitimate concern. If you disagree with me, disagree with me. But that is the concern, and I wanted to lay it out here because it's not about court packing. It's about the integrity of the court, and it's about the unfortunate comparison that can be made now between the captured agencies delivered through picking of their membership, and what looks more and more like a captured court delivered by the picking of its membership in secret with a very, very high ticket price to be in the room where the picking took place. So, like I said, colleagues can agree, colleagues can disagree with, we all have our shots to make our cases. Because this has come up tangentially in multiple different ways, I wanted to take this moment and lay out what my case is and explain it as clearly and simply as I can. And I thank the chairman for allowing me that opportunity. And I yield back my remaining 7 minutes. And I congratulate, Your Honor, you for the patience that you've shown with all of us. It's not over, but it's close.
Thank you, Senator.
Thank you, Senator Whitehouse, and of course, you've joined the Hall of Fame, yielding back 7 minutes. Senator Lee?
Thank you, Mr. Chairman. Thank you, Judge. I want to talk next a little bit about a case that you were involved in, a case called Coal River Mountain Watch versus United States Department of the Interior. It was decided a ruling that you issued in 2015 while in the federal district court. I know you've handled a lot of cases.
I have.
I can't imagine that by merely triggering the case name that would necessarily bring it back. But this case involved a challenge to an administrative action within the Department of Interior on some issues bearing on coal mining within the state of West Virginia. There were two parallel challenges brought against that administrative action. One in a federal district court in West Virginia, where the land in question was located, and another in the U.S. District Court for the District of Columbia, where you sat. The government defending itself against that action brought by some environmental groups asked that you dismiss the D.C. case so that the matter could be litigated in West Virginia. You denied that. Can you, based on my description of the facts, does that ring any bells, and can you tell me why you might have denied it?
Thank you, Senator. It actually doesn't. It sounds like, dozens of cases that I handled with similar issues and requests. Something like a motion to dismiss is early in the action.
Sure.
And so denying a motion to dismiss is pretty routine in the District of Columbia.
I understand, and I'm sure you handled a lot of those all the time as a district judge. The reason I raise it is just because it relates indirectly to some concerns that I've got that are somewhat unique to the Western United States. We have a lot of cases that involve the U.S. Department of the Interior and agency actions taken relative to the public land that we have. In every state east of Colorado, the federal government owns less than 15% of the land. In most of those, it's much less than 15%, in the single digits or low single digits. In every state, Colorado and west of Colorado, the federal government owns more than 15% of the land, and most of the time, it's a lot more. In my state, it happens to be about 2/3 of the land that's owned by the federal government. As a result, it complicates our ability to do just about everything we do, whether it's recreation, construction, oil and gas development, whether it's just accessing people's farms and ranches, or even something as simple as trying to fund local fire, police, search and rescue operations. All these things are affected by the excessive ownership of federal land by the federal government and the way it's often managed. Sometimes decisions made at the federal level are challenged in parallel actions like these. One in the forum state, in the host state to where the action is happening, another in D.C. And I'm always concerned about forum shopping. And I'm sure that's something you watched out for as a judge and saw forum shopping from time to time. It's also something that touches on an issue that involves statutory interpretation. There's something called the Antiquities Act, passed 110 years ago or so, designed to give presidents of the United States the authority to designate parcels of federal land as national monuments. The text of the statute states that the limits of the parcels in question should be, quote, confined to the smallest area compatible with the proper care and management of the objects to be protected. Now, given that these presidential proclamations tend to be broad, it's sometimes the objects to be protected are also broad. And as a result of that, it's difficult to tell what the limits are. Do you have any reaction as to how we could discern that, how we could define any meaning out of that? It's got to mean something. The text of the statute, you try not to leave language simply unaddressed or meaningless in a statute. Do you have any thoughts on how a statute like that, saying that it should be confined to the smallest area compatible with the proper care and management of the objects to be protected? Any thoughts briefly on that?
Well, Senator, if I were presented with a case with that statute in that circumstance, I would proceed as I always have. You would have to understand the parties' arguments about the particulars in the case. What does the presidential proclamation say? To what does it relate? Whether there are any precedents in this area that further define or further address what Congress intended with respect to the statute at issue.
And I would assume that it would also matter if the government's lawyers defending the president's action made an argument that would leave the interpretation open-ended and meaningless.
Well, as part of your interpretive exercise, as you're considering the parties' various arguments, one that did not account for all the words in a statute would be one that you would
Excellent.
might
Excellent.
not
Yeah,
might not agree with.
No, I get it. And this is one of the things that I've appreciated about what you've told us in these hearings. I really like the way you've described the fact it's important to construe the text that you're asked to interpret. And in interpreting that, you look at the language and you're endeavoring to figure out the original public meaning. And I think that is a very helpful thing. All right, let's move to a different issue a moment ago. Now, you clerked on the U.S. Supreme Court for Justice Breyer in October term 1999, is that right?
That is right.
That was the same, and you clerked for Justice Breyer.
I did.
And that was the same year that the Supreme Court issued its decision in a case called Stenberg versus Carhart. This is the case where the Supreme Court of the United States struck down a Nebraska law prohibiting partial birth abortion in the absence of circumstances where the baby posed a threat to the life of the mother. Now, to be clear, the law prohibited a procedure where the abortionist causes an unborn baby to be partially delivered by the mother, and then the abortionist intentionally kills the baby outside the womb by puncturing its skull with scissors and then collapsing the skull. This is gruesome, and I don't like having to quote this, but it is relevant to the topic we're covering here. Justice Kennedy described it this way in chilling terms when in his dissent, when he describes the fact that when scissors are inserted into the back of the head, the fetus's body, wholly outside the woman's body and alive, reacts as though startled and then goes limp. Justice Scalia, in his great eloquence, lamented the ruling, but also expressed optimism for the fact that future courts would get it right, saying, quote, "I'm optimistic enough to believe that one day Stenberg versus Carhart will be assigned to its rightful place in the history of this court's jurisprudence beside Korematsu and Dred Scott. This method of killing a human child, one cannot even accurately say an entirely unborn human child, prescribed by this statute is so horrible that the most clinical description of it evokes a shudder of revulsion." We then saw a few years later the Supreme Court of the United States issue a different ruling. The Supreme Court issued a different ruling in a case called Gonzalez v. Carhart. Gonzalez v. Carhart upheld a different statute. This one was federal rather than state, but it was a different federal statute that also prohibited partial birth abortion. Judge Jackson, can you distinguish these cases for me? What was the difference between Gonzalez v. Carhart, where the partial birth abortion ban in question was upheld, whereas in Stenberg v. Carhart, it was invalidated?
Thank you, Senator. I don't have the opinions in front of me. I think it had to do with the method of extraction, the fact finding related to the procedure. In one case, the district court had made some findings and the court felt bound by them. And another, there was considerations beyond those that were previously relied upon. So there were distinctions that the court looked at and considered in the cases, but yes.
Let's talk about court packing for a minute.
Yes.
One of the reasons court packing concerns me, one of the many reasons, is because it's not prohibited, in the first instance, it's not prohibited by the Constitution. There's nothing in the Constitution that says that Congress may not change the size of the Supreme Court. There's no limitation on that. We have, for 152 years, stuck with the number 9. It has worked, and in the absence of an argument saying that that number is too low, that the court is too small, that from a workforce standpoint, we need to expand it. It's difficult to imagine why it would be a good idea to change it, particularly because if you increase the size of the court in one fell swoop, and you do that for partisan political purposes, allowing one president, the current president, to have a disproportionate impact on the court and to change its rulings, that portion of the court's docket that tends to be more politically contentious. It can turn the court into a political football of sorts. Given the fact that our Supreme Court justices serve for life, once you do that, it becomes something of a one-way ratchet, always expanding, never contracting. Before long, you could see an increasingly larger court, with the court expanding each time a different party secures the coveted circumstance of a majority in the House, majority in the Senate, and controlled by the same party of the White House. And so this is why it concerns me. I understand that why it is that the canons of judicial ethics don't allow you to comment on matters that might come before you. This is one that could not come before you as a justice. This is a non-justiciable political question. It's committed to the two political branches of government. There's not even a constitutional challenge that could lie to it, even though it would undermine the separation of powers in the Constitution, as I see it. It's not unconstitutional. So it couldn't and it would never come before you. Last night when you were asked a question by my colleague, Senator Kennedy, on this, you acknowledged that you have an opinion. Did I understand that right? You have an opinion on court packing?
Senator, I have a lot of opinions. I have opinions on I'm a human being, and I have an opinion on a lot of things. The reason why, in my view, it is not appropriate for me to comment is because of my fidelity to the judicial role. I understand that it's a political question, and that is precisely why I think that I am uncomfortable speaking to it.
No, I understand that, and I respect the impulse. I respect the overall issue, and I think it's better for Article III judges and justices ordinarily to not wade into the political thicket. This one I do think is different because, number one, as I say, it can never come before you. Number two, it does have an impact on what you would be doing, and you also as an Article III judge, someone who's served for nearly 9 years as a federal judge, you've developed experience and intuition and a thorough understanding of our federal court system, and that's why I think your perspective on it would be valuable. The reason it concerns me so much is that even when court packing doesn't succeed legislatively, it can leave an impact. The last time this was attempted was in 1937. President Franklin D. Roosevelt was upset at the Supreme Court on a number of bases. He didn't like the then 32-year-old precedent of Lochner versus New York, where the 5 conservatives on the Supreme Court engaged in an active judicial activism, reading something into the Constitution that wasn't really there. Some people disagree with me on this, but it wasn't there. And they imposed that. But the bigger reason was he didn't like the court's interpretation of the Commerce Clause. It was that interpretation of the Commerce Clause, the one we discussed yesterday, you know. Prior to 1937, you had the Supreme Court agreeing as far as the channels and instrumentalities of interstate commerce that we talked about yesterday. You had the court more or less in agreement over time as to the impact of the Dormant Commerce Clause. But as to the substantial effects test, that didn't exist yet. It required something much closer to an interstate commercial transaction in order for Congress's Commerce Clause authority to kick in. There were the so-called four horsemen of the apocalypse, as FDR affectionately called them, four conservatives who were consistently pushing for limits on Congress's authority. And then you had other justices who would sometimes join with them. Usually that included Justice Owen Roberts, who had stood with them in maintaining narrower authority for Congress under the Commerce Clause. All that changed when on April 12, 1937, 2 weeks to the day when the case often associated with the so-called switch in time that changed 9, West Coast Hotel versus Parrish, where they undid the Lochner precedent. April 12, 1937, the Supreme Court decided a case, NLRB versus Jones and Laughlin Steel, that forever changed and magnified, expanded the Commerce Clause in a way that, had it been through a constitutional amendment, it would be among the most significant, impactful constitutional amendments ever adopted, and yet it's rarely discussed. This case resulted from one vote, one person on the Supreme Court who changed his vote, Associate Justice Owen Roberts. It's widely believed, and I believe it based on what I've researched on it, he was influenced heavily by FDR's court packing plan. He didn't want to be on a court that was packed. He didn't want, he convinced himself that he made that switch in order to save the court as it was. And that has changed everything. It's led to a much bigger, more expensive, more intrusive federal government. We can disagree as to the policy merits of that, but it did change the Constitution. That's why I worry about that. So I hope, I understand you don't want to answer it. I hope that between now and the end of the day, you'll see fit to tell us what your opinion is. I do think it's worth discussing. Let's talk for a minute. Got just moments left. I want to get back to your sentencing approach. Now, when you approach these child pornography cases, what you're describing in many circumstances is an overall concern that you've got with the sentencing guidelines, and particularly that portion of the sentencing guidelines that deals with child pornography cases. This showed up in the transcripts of some of your sentencing hearings, including the transcript of your sentencing hearing in the Hawkins case. I turn to that to page 38, lines 17 to 24 of that transcript, and here's something you say in that Hawkins case. And I believe this was the 18-year-old defendant that you sentenced to 3 months in prison, when the lower end of the guidelines range would have been 97. I think the higher end would have been in the 120s or something like that. You said, and in your case, this is you speaking to Mr. Hawkins, in your case in particular, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims, as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense. I've got a couple of questions about that. Were those, you start out that paragraph sounding like you're making a determination as to him, but then the observations you make in that paragraph seem to apply broadly. Is that right? So
Senator, I don't have the transcript of Mr. Hawkins' case. I recall that I found that case, like all child pornography cases, to be difficult, really difficult. And his case I recall, was in many ways an outlier in terms of the various considerations that Congress required me to take into account.
But there were prepubescent victims that were at stake in that.
I don't remember how many. I don't remember the circumstances of his actual crime. What I will say is that, consistent with Supreme Court case law and Congress's statute in this area, judges have to take into account a number of factors and the guidelines, which are no longer, I won't say not mandatory. You have to calculate the guidelines. They're no longer binding. And the Supreme Court has said that under the statutory scheme, judges have discretion.
But Mike, I'm almost out of time.
Yes.
Here. I want to make the point.
Yes.
Hawkins, as I recall, and as Senator Hawley discussed yesterday, he specifically asked for images of 11 to 17-year-olds. So I don't understand how that can be a
hate when this does that. Every 2 hours
the
they ask you
images
to
become easier over time
refresh it.
to transmit and receive and store because of computers. I actually think it cuts in precisely the opposite direction that you described. It makes it more severe, not less. I see this as an aggravating factor, and that is of great concern to me. I see I've exceeded my time. Thank you.
You may respond.
Senator, as in every child pornography case that I sentenced, I considered all of the evidence, all of the relevant factors. It is not the same exercise to look at a transcript, to think about guidelines, to not have in front of you the individuals, the victims, the pictures, the circumstances that trial judges have to review in these cases or any cases. I understand, Senator, that there are some questions about records, et cetera. Courts have all of the evidence, and courts have all of the recommendations of various parties, and courts have, under Congress's authority, the responsibility of using our judgment to make determinations that are sufficient but not greater than necessary to comply with the purposes or promote the purposes of punishment, taking into account things like unwarranted sentencing disparities. And it may seem like an easy exercise. It may seem in retrospect, when you look back at a few pieces of data, that courts have not done what it is that they're supposed to do. But what I can assure you is that I took every one of these cases seriously in my duty and responsibility as a judge, and I made my determinations in light of the seriousness of the offense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment, and all of the other factors that Congress prescribed.
Okay, but you keep resetting that standard, and yet you specifically excluded from consideration the fact that he had requested and obtained images, prepubescent child pornography images.
Senator, I didn't exclude it. I didn't exclude it. What I did was I looked at the guidelines, which is what the Supreme Court requires, and I was making policy determinations as the Supreme Court says that judges are to do.
Look at
in
page
these
38
situations.
of your transcript. It looks to me like you excluded it, and your action sentencing him to 3 months for one of the most heinous offenses imaginable. Keep in mind, because these are transmitted
Senator,
electronically, they're there for years. They re-victimize these victims
Senator,
the rest of their lives.
We're asking everyone to try to stick with the 20 minutes, please. Next is Senator Klobuchar, but before recognizing her, I'd like to ask consent to enter into the record a support letter for Judge Jackson from 48 former federal prosecutors in South Florida. Without objection, Senator Klobuchar.
Thank you very much, Chairman Durbin. Welcome back, Judge Jackson. Yesterday, you and I discussed the court's increasing reliance on issuing unsigned orders on its shadow docket. And less than an hour ago, the court once again used the shadow docket to throw out Wisconsin's redistricting maps. And because this decision just came out, I don't expect you to have immediately reviewed it. But I just want to make this point that in her dissent, Justice Sotomayor, joined by Justice Kagan, called the court's move unprecedented. She noted that in an emergency posture, the court summarily overturns a Wisconsin Supreme Court decision resolving a conflict over the state's redistricting, a decision that was rendered after a 5-month process involving all interested stakeholders, based on an obligation that is, these are her words, hazy at best, even though summary reversals are generally reserved for decisions in violation of settled law. And again, I don't expect you to be familiar with this case, but I do want to point out that this underscores the point that I made yesterday, that the court's increasing practice of using the shadow docket to decide cases that have grave consequences for our democracy, including the right to vote, that you and many other nominees have said is fundamental, is incredibly troubling. You had in the other case I mentioned yesterday where Justice Roberts dissented, the Texas abortion bounty hunter case, that should not have been done on the shadow docket. And while I'm not going to ask you about this because you couldn't possibly have read it, just your record of writing decisions that are thorough and listening to litigants in cases, could you just generally talk about the importance of having full briefings on the merits as well as public oral arguments if you believe in transparency?
Thank you, Senator. As a judge in my work over the last decade, I've seen that it is very important, at least to me in my time as a judge up to date, to hear arguments from all sides in a case. The duty of a judge is to make determinations, and under our system of adversarial proceedings, you make determinations based on arguments, and it's important to do so. I know that with respect to the emergency docket, you haven't asked me the question about it, because I would say what I said before, which is I would benefit from being able to speak with the justices. I understand that there's a need to balance getting full briefing with emergency circumstances, and the court has long had in its procedures the ability to rule quickly on various cases. It's also my understanding from my time clerking on the court that the court does recognize the value of allowing things to what we call percolate, meaning lower courts to hear issues. And my understanding is that at least in some of the recent cases, the justices have had oral argument related to some emergency matters. But from my perspective as a judge in the work that I've been doing, I know that it's important to hear from the parties.
Another hallmark of your work has been taking complex issues and making them accessible to the public. So much so that I actually referred to one of your opinions from a debate stage in Los Angeles, saying, as a wise judge said, those were my words, I guess I was ahead of my time, the president is not king in America, the law is king. I paraphrased it. That was a written opinion that you wrote that was over 65 pages long, relied extensively on Supreme Court and circuit precedent. It was Committee on the Judiciary v. McGahn. And could you talk about really two things? The importance of having the law written in terms that are easy to understand by people. And then secondly, your opinion was actually a narrow one. It required Mr. McGann to appear to testify, but that said he remained free to assert any legally applicable privilege in response to the questions asked. So what you did there was a narrow opinion. What role do you think that narrow rulings play in helping to maintain the legitimacy of the court? Why is it important to have plain language in orders?
Thank you, Senator. Well, I'll start with the second first. I think that, as we've been discussing, we have a rule of law in this country which requires a certain amount of predictability and stability in the law. If there are big shifts in terms of legal principles and doctrines and whatnot, it could lead to people not understanding that judges are ruling on legal principles. It could lead to undermining public confidence, thinking that judges are injecting their own policy preferences rather than following the law in terms of their rulings. And so to further predictability, stability, there are many doctrines in judicial practice. There's stare decisis, which is the principle that if something has already been decided, very similarly, you, at least if it may be binding on you if you're a lower court, but at least you have to contend with it because that is the law that existed before you got the case, and you don't want to make a big shift. And then there's also the principle that, the understanding that when you are announcing rulings, you are building on what exists before. And so you don't want to make a big shift if you don't have to, because if you can find a way to rule incrementally in a more narrow way, it keeps the law stable, is a part of the proposition that I mentioned before. In McGann, in particular, it was a case in which there was a precedent directly on point from my district. It was not binding on me, but the exact same set of circumstances and arguments had been presented to another judge in my district. I believe it was something like 10 years prior to my case. And so we had law that governed the circumstance, and I looked at that, determined it was persuasive, and that I should continue the principles that had been laid down by in the prior case. Also, in accordance with those principles, the prior judge and I made the determination that when the president claims absolute immunity, the argument was that the person who had been subpoenaed by the legislature, a former employee of the White House, could say that they had immunity of some sort. In other words, it could have invoke executive privilege in response to particular questions, but they couldn't say, I don't have to show up at all. And so the argument that was being made was when the House of Representatives issues a subpoena and says, show up on this day at this time to answer questions, can that person just ignore and say, I have immunity, I don't have to follow the law, in other words, respond to the subpoena? Or do I have to show up and sit there and listen to the questions? And if there are things that I believe I can't answer because they're privileged, then you invoke the privilege. And the prior case had said in this narrow way, you have to show up. You don't necessarily have to give the information. That's determined on a question by question basis, but you have to show up. And that's what I held in that case as well. And it's important to be clear in your rulings so that people understand that judges are ruling consistent with the law and not their own personal views.
Right. And speaking of being clear and being careful in your rulings, some of my colleagues have, I think, given not a necessarily true view of your whole record, because when it comes to your rulings being upheld, the numbers show that out of over 550 cases, your district court cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam v. United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, then siding with you in an opinion written by Justice Thomas and aligned with your view. Do you want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there. Military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes, about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The D.C. Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court, and as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. The court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there will be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, "Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views sometimes become the dominant view." When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there. They said, Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future. What do you think is the purpose of a dissent? And do you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. On the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not. There is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that led to Brown versus the board. So there is the opportunity for justices to describe their views in ways that become persuasive to others in the future.
Thank you for all you've given us the last few days. We look forward to working with you. Thank you.
Thank you.
Thanks, Senator Klobuchar. And we're going to break now for a 30-minute lunch. I'd say to everyone that when we return, if we stick to 20-minute rounds and don't yield back time, we'll be finishing in something around 4.5 hours, which would take us to about 7 o'clock. So that doesn't include a break, but we'll consider that later on. Thank you, Judge, again.
Okay, so what do we see today so far? Same as yesterday, with the judge bouncing around answers. A lot of talk by a lot of people saying nothing, signifying nothing, as I remember something like that. All much to do, signifying nothing. Where's that one come from? And we heard a couple of odd things. Yes, we did. Earlier we heard the judge say that if the decision was wrong, and it is now precedent, that SCOTUS, even after knowing it's wrong, will not overturn its previous decision, which flies in the face of everything we know, doesn't it? I mean, it's like saying, okay, Well, we know we were wrong, but we're going to stick to the previous precedent, even if it's unconstitutional. We got to wait and see Senator Kennedy later. He's always good. And then we get to this one point where she said about how she was sentencing people, about a sentencing disparity. Now, is that code for racist? Is that code for, okay, the defendant was a black guy, so we got to let him off on easier terms? Just some of those things like that made me question. I wouldn't vote for this judge, even though she says she's a textualist. She has danced around questions about the Constitution. It's it just didn't seem right to me. She was, yeah, they all like to talk. They all love to hear their own voices. I swear. Uh, a simple question that should take 3 sentences is expanded to 10 minutes, and then the answer from the judge takes another 5 to 10 minutes when all she had to do was say yes or no. Um, really? What a way to eat up time. I mean, you saw one senator there, and I forget who it was. Just asked the question, and most of the time her answers were either yes or no, but did try to expound, and he said, "No, all I want to know is the answer. I don't need the background. I don't have the time." And he went through his list of questions like that. Uh, yeah. What we're gonna do? I've got to go do a couple things here. I'm gonna leave the streamer playing. Um, Usually, what they do is they show highlights after about 5 or 10 minutes of this crap of what happened during the session. If I get any other information, I'll get it to you. If I can get some of the highlights, I'll get it to you. But usually, C-SPAN is pretty good about doing replays 5 or 10 minutes after the event. Here we go. Here's like this replay from Lee. Uh,
That attitude and you will become a member of the U.S. Supreme Court.
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced
See that? All she
when
said,
the public
all she had to do was say thank you,
understands
Senator, and
the
then she goes into a
reasons
5 minute
that a
tirade.
judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
And that exchange that we just showed you, of course, from earlier today. Senators today, during their 20 minutes, are asking follow-up questions. Senator Lindsey Graham used his time challenging Judge Jackson to clarify her position on sentencing child pornography criminals.
I have no doubt that you find child pornography disgusting as the rest of America. You're a mother. You seem to be a very nice person. Are you aware of how many images are out there on the internet involving children and sexually compromising situations?
Senator, I'm not aware of the numbers, but I've seen the images in my
and they are disgusting,
role
right? Well, let me tell you the
judge.
numbers. In 2021, the National Center for Missing and Exploited Children Cyber Tip Line received 29.3 million reports of apparent child sexual exploitation containing 85 million images, videos, and other files. That's in 2021. It's up. In 2019, it was less. So there's an epidemic of this on the internet, that if you go out on the internet, there are millions of pictures of kids being abused. When it comes to sentencing child pornography possession cases, do you routinely discount the fact that a computer was used?
Thank you, Senator, for allowing me to address this concern. The guidelines related to child pornography were drafted at a time in which a computer was not used for the majority, if not almost all, of these kinds of horrible crimes. The guidelines have enhancements in them.
In two areas that you said you disagree. What are those two areas?
At the time that the guidelines were drafted, it was an aggravating factor, a substantial aggravating factor, to use a computer in order to distribute and disseminate the images, because the ordinary crime was not committed by computer. So the
Would you now agree with me that computers are sort of the venue of choice for child pornographer people?
Yes, Senator.
Okay, so here's my point. If you believe, as I do, the computer has created a bigger demand, there are more photos out there because of the internet, more websites exposing this garbage. Wouldn't you want to deter people from going down that road?
Senator, this crime is among the most difficult.
No, answer my question. Wouldn't you want to deter people from going down the road of using the computer that allows these people to have access to millions of photos because of the technology? I want those people deterred. So if
Senator-
you're listening to my voice today and you're on a computer looking at child pornography and you get caught, I hope your sentence is enhanced, because the computer and the internet is feeding the beast here, that all these images out there are going to be more over time because people use computers. Now, didn't you also say that the number of images should not be considered as a sentence enhancement?
Senator, with respect to the computer, one of the most effective deterrents is one that I imposed in every case and that judges across the country impose in every case, which is substantial supervision. Any of these
Wait a minute, Judge. You think it is a bigger deterrent to take somebody who's on a computer looking at sexual images of children in the most disgusting way is to supervise their computer habits versus putting them in jail?
No, Senator, I didn't say versus.
That's exactly what you said. I think the best way to deter people from getting on a computer and viewing thousands and hundreds and over time, maybe millions, the population as a whole, of children being exploited and abused every time somebody clicks on, is to put their ass in jail, not supervise their computer usage.
Senator, I wasn't talking about versus.
You just said you thought it was a deterrent to supervise them. I don't think it's a deterrent. I think the deterrent is putting them in jail.
Senator,
Does
would you let
sentencing
her
have
respond?
a deterrent component?
Senator, would you let her respond?
Yes. Does sentencing have a deterrent component?
Yes, Senator, deterrence is one of the purposes of punishment, and Congress has directed courts to consider various means of achieving deterrence. One of them, as you've said, is incarceration. Another, as I tried to mention, was substantial periods of supervision once the person...
So if I could may ask you, in your view, it's more of a deterrent to have somebody substantially supervised in terms of their computer use who's looking at child pornography than it is to put them in jail?
Senator, I'm not saying it's more or
That's
less.
exactly what you're saying.
What I'd like to point out is that if we're going to, let me say it this way. Congress has authorized courts to use a number of different means to achieve the purposes of punishment.
And one of them is an enhanced punishment by using a computer.
The enhancement with respect to using a computer
to apply. The use of a computer is an enhancement. You've also said you're not going to hold the number of images that the person has looked at as a sentencing enhancement factor. Is that true?
No, Senator, it's not the number of images that the person has looked at because we don't have that information.
Well,
It is the number of images that they've either received or distributed that are...
we don't know if they looked at them, but you're not going to hold it against them that they received 10,000 images versus 100.
That's not what I've said, Senator.
Well, here's what you said. I've decided to apply my general policy disagreement with respect to those enhancements. At least that is the computers and the number of images. Folks, what she is saying, the reason she's always below the recommendation, I think, is because she doesn't use the enhancements available to her. She takes them off the table. And I think that's a big mistake, Judge. I think that every federal judge out there should make it harder for somebody to go on a computer and view this filth. That if you use that venue, which is the venue of choice for all these child pornography cases, that you use it against them. I think the more you download, like drugs, the more you have, the more you should go to jail. You've made a conscious decision to disregard those two enhancement sentencing factors, and I think that is a wrong way to go in terms of deterrent. To me, putting somebody in jail for using a computer is more of a deterrent than supervising their activity of watching the computer. That's just a difference that we have. I know I'm out of time, and listen, you've lived an incredible life, but here's one thing that won't happen to you as we wrap this up. How would you feel that if I'd had a letter from somebody accusing you of something, a crime or misconduct, for weeks, and I give it to Senator Durbin just before this hearing's over, and not allow you to comment on the accusation? How would you feel about that?
Senator, I'm not sure. I don't understand the context of the question.
Well, did you watch the Kavanaugh hearings?
No, sir.
Are you familiar with what happened in the Kavanaugh hearings?
Generally.
Senator, your time is.
Well, please, Mr. Chairman. So to be honest, it's a minute and 47 seconds. She filibustered every question I had, and she has a right to give an answer, but I'm trying to make a point in 20 minutes. You were here for Kavanaugh. If she's confused about what happened, some people on the other side had an accusation against Judge Kavanaugh that during high school, he sexually assaulted somebody. And the rest is history. That was known to the people on the other side and never revealed during the meetings they had with Judge Kavanaugh. It was literally ambushed. He was ambushed. How would you feel if we did that to you?
Senator, I've appreciated the kindness that each of you has shown me to see me in your offices, to talk with me about my approach.
But my question is, what if during our 15-minute exchange, it was very pleasant? You're a very nice person. You have a lot to be proud of. I would never do that to you. If I had some information that's sketchy at best, that somehow you've done something wrong, I promise you, just from human decency, I would share it with you. I would not disclose it at the last minute of the last day of the hearing, and I've already given it to a newspaper so the whole country can read about it before you ever said a word.
Senator, she's had nothing to do with the cause.
No, but I'm asking her about
you won't even let her finish
how
your
she may
response.
feel about what y'all did.
Senator, your time has expired, and I'm going to give her an opportunity to finally complete an answer.
So, if I could
Just
address,
answer the question.
Senator, I don't have any comment on what procedures took place in this body regarding
What'd you think about
Justice
the Kavanaugh hearing?
Kavanaugh. What I'd like to answer is your points about my sentencings in child pornography cases. The point of the guidelines is to assist judges in determining what punishment to provide in cases. And there are horrible cases, but the idea is that between the range of punishment that Congress has prescribed, judges are supposed to be providing proportional punishment based on what a person has done. The sentencing scheme doesn't place everybody at the same level. The point of judging and the guidelines is to look at what has happened in a case, compare defendants to each other in terms of what they've done, and give proportional penalties based.
Mr. Chairman, this is she has said, Mr. Chairman, she does not use sentence enhancements in the area of somebody using a computer for everybody.
Can I explain why, sir?
I'm going to give the witness an opportunity to respond to you, Senator.
Finally.
At
Why?
the time that the guidelines were created for child pornography, this crime was primarily being committed by people who were literally mailing 1, 2, 5, 10, 100 photos at a time.
How's it being committed now?
Would she please
Go
let
ahead.
her complete her answer?
Go ahead.
As a result, the commission determined in the guidelines that it was a substantial aggravating factor if the facts of the case demonstrated that someone had been distributing hundreds of images, because what that meant was over this long, maybe it was a long period of time, They had collected one photo at a time. They had amassed it. They had potentially mailed one at a time. And that showed really aggravated, terrible conduct. I'm not saying as a baseline it's not terrible. It's all terrible. But what we're doing is we're differentiating among defendants. So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good. Good.
I understand,
Absolutely
Senator, but
good.
what
I hope you
we're
are.
trying to do.
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of children in sexual exploitation. So you don't think that's a bad thing? I think that's a horrible
That's not
thing.
what the witness said, and she should be allowed to answer this question once and for all.
Senator, all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change, such that in 2 seconds, someone can receive or distribute thousands of images, that's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
Well,
and so what we're trying to do is be rational in our dealing with some of the most horrible kinds of behavior. This is what our justice system is about. It's about judges making determinations in meting out penalties to people who have done terrible things.
It is not rational to take the venue of choice of child pornographers, the computer that have 85 million images on it, and not consider that feeding the beast. We're trying to get people to stop this crap. So when you troll on the internet and you pull down thousands of images of children from the internet, I want you to stop that. I want people to go to jail who do that, because you're feeding the beast. We have a bill here, the Earn It Act, that would allow the victims who are on the internet over and over again to sue the media companies that provide these images. We have a fundamental differences of how you deter crime. I think the best way you deter crime when it comes to child pornography is you lower the bloom on anybody who goes onto the internet and pulls out these images for their pleasure.
Senator, every person in all of these charts and documents I sent to jail because I know how serious this crime is. Every person, I discussed the harm of these terrible, terrible images to the victims who are portrayed in them. I talked about what this crime does to the children who are being abused in these photos, and on the other side of their terms of imprisonment, I ensured that they were facing lengthy periods of supervision and restrictions on their computer use so they could not do this sort of thing again. That's what Congress has required of judges, and that's what I did in every case.
You always were under the recommendation of the prosecutor, many times the parole people. And to be honest with you, Judge, a 32-year-old man who sent an image of his own 10-year-old daughter you substantially reduced the not only the guidelines, but the recommendation. And all I can say is that your view of how to deter child pornography is not my view. I think you're doing it wrong, and every judge who does what you're doing is making it easier for the children to be exploited. If you're on a computer right now looking at a kid in a sexually compromising situation and you get caught, I hope nobody gives you a break because you used the computer.
The conduct that's been described is reprehensible, and I think everyone in this room agrees. And the fact of the matter is that I'm co-sponsor of your bill, the Earn It Act, and I believe that we should be doing our job here. But part of our job, we have failed in responding to the changing circumstances that face this crime. What has it been, 15 or 16 years? She is currently not an outlier in sentencing. 70% of the federal judges face the same dilemma and wonder why Congress has failed to act and when it will act.
This is our fault?
Partially it is, Senator. To be honest with you, it is. We have to upgrade these guidelines and decide whether we're going to stick with the Supreme Court decision that they're not mandatory.
And live again for the final day of questions for Judge Ketanji Brown Jackson. The Judiciary Committee in a break for lunch now. We're expecting them to come back in just a couple of minutes. Senator Ted Cruz will start questioning at the end of this recess. A reminder that along with coverage here on C-SPAN television, you can also watch online at cspan.org and with our free mobile app, C-SPAN Now. When the hearing resumes tomorrow, the Senate Judiciary Committee will hear testimony from outside witnesses, including members of the American Bar Association, Congresswoman Joyce Beatty, Mr. Wade Henderson, who's the president and CEO of the Leadership Conference on Civil and Human Rights, and Alabama Attorney General Steve Marshall. Live coverage of the hearing gets underway tomorrow at 9 a.m. Eastern here on C-SPAN. On this related note, the Associated Press reporting the Supreme Court has declined to say whether 73-year-old Justice Clarence Thomas remains in the hospital. Though he had been expected to be released by Tuesday evening, the court said Sunday that Justice Thomas had been admitted to Sibley Memorial Hospital in Washington Friday after experiencing flu-like symptoms, and he was diagnosed with an infection. His symptoms are abating, and he was expected to be released Monday or Tuesday, the court said in a statement at the time. But this morning, Wednesday morning, court spokeswoman Patricia McCabe, said that she had no update to provide.
That's so funny.
And we're just minutes away from more questions for Supreme Court nominee Ketanji Brown Jackson. There'll be questions from 13 more senators when they resume. Senator Ted Cruz is up first. Live coverage here on C-SPAN. Scenes inside the hearing room for the Senate confirmation hearing of Judge Ketanji Brown Jackson while we wait for more testimony this afternoon. And it's going to get underway in just a minute here. We'll show you a shot of what we call the stakeout area. This is where senators could come to make remarks to reporters. This is right outside the hearing room in the Hart Senate Office Building. You also see the queue of people lined up there behind the podium, some in front. Those are folks who hoping to get into the hearing room to watch testimony this afternoon. Attendees are given a set amount of time to watch the hearing, and then they have to rotate out to let others in.
Madeleine Albright, first female Secretary of State, died. She was 84. Wow, that's got to be news. That should make the news, right? Oh, let's see. Anything else happening? Oh, this thing is so slow. Well, the U.S. government has formally declared that the members of the Russian armed forces have committed war crimes in Ukraine, Secretary of State Antony Blinken said in a statement Wednesday.
So a little bit of a delay in the start of the next set of questions for Judge Ketanji Brown Jackson. The committee is in a break for lunch. They were expected back at 2:20, but there's also a Senate vote underway right now. So we have seen the committee chair in the room, so it should be starting in just a minute here. Senator Ted Cruz will start questioning when they return. We have just learned from NBC News that Madeleine Albright, the first woman to serve as U.S. Secretary of State, has died. Her family released that in a statement today. She was 84 years old. Then President Bill Clinton named Albright U.S. Ambassador to the United Nations shortly after she was inaugurated in 1993, and then nominated her as Secretary of State 3 years later. She served in that post for 4 years, and she promoted the expansion of NATO and military intervention in Kosovo. In 2012, then President Barack Obama awarded her the Medal of Freedom, the country's highest civilian honor.
Okay, here's a couple of strange thoughts for you. We know that Psaki, Circleback Psaki, got COVID, but at the same time, Hillary Clinton got COVID. Just throwing that out there. And I had a thought that, weird as it may sound, we're all wondering who's behind, who's running the strings for Biden. Well, could it be that it's Hillary Clinton, that the DNC said she's never going to win? There's no way she could win. Even with cheating, we can't win her, get her to win. So why don't we let this idiot take the shot, take the presidency, and let her run everything behind the scenes? I don't know. I've not seen where she's been, when she's been, or anything else like that, but it's just another weird thought. Weird thoughts come to my head all the time, and sometimes they turn out true. I don't know. But strange that Psaki and Hillary Clinton got the COVID at the same time, isn't it? This should be interesting. Ted Cruz is going to be the first one up. He's usually pretty good for something, isn't he? Here come the judge, here come the judge. Everybody stand, because here come the judge.
Welcome back, Judge. As you can see, things get off the rails here when they decide to have a floor vote. We'll do our best to stick with the program and finish this in a proper way. The next up is Senator Cruz of Texas.
Thank you, Mr. Chairman. Judge, good afternoon.
Good afternoon, Senator.
Under Article 3 of the Constitution, federal courts have jurisdiction over only cases and controversies, which means under the Constitution it has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case, that plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the Board of Overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article 3 standing to challenge a gender-based rule, regulation, policy, without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern leftist sensibilities, if I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article 3 standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article 3 standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
Well, I'm asking you
kinds of
how you would assess standing if I came in and said, I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a determination.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 U.S.C. section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there was no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So, under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are very horrible
I'm asking you specifically
crimes,
about the Hess
and
case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engage in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child, and you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, in half of them, in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accused, accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying. In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator. You've picked out, I don't know, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in every
These are your child
case,
porn cases.
in every case, Senator, I look at the evidence, I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence, I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who...
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance, with Mr. Chazen, you said, among the defendants nationwide who received a below-guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing
And
every one of your
I-
cases. So
I
if you're
understand
not
that.
going to explain it, then I'm
Senator,
gonna-
would you please let her respond?
No, not if she's not going to answer my
Well, if
question.
you're just going to give a speech, then you shouldn't engage in
And
questioning.
you are not taking my time. If you want to filibuster, you're welcome to do so, but do it
I
on your
would
own
at least
time.
give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why
Please
she
allow
sentenced-
her to answer the
I
question.
asked her why she sentenced Chazen to 28 months when comparable defendants, in
So
her
let's hear
own
the
words,
answer.
were sentenced to substantially higher, and she said she's not going to answer. Did you? I mean, I would welcome your
I didn't
answer,
hear that.
please.
Senator, I didn't say I'm not going to answer.
Okay, well
I
then
said
please
my
tell us
answer.
in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
By the way, you know, one of the
ruled.
striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point, and the prosecutor says, I understand from my experience before Your Honor's objection, policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated, and you sentence them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain people with vile crimes, and you have language saying they're vile crimes, but then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
my job is to make
Chairman
sure
Durbin, I'm not interrupting your questioning.
I'm asking you to give her a chance to answer.
But
You
she's
refuse to do it.
consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is, the case that I was reading from your transcript was Cooper, but Chazen, all right, let's get to Chazen. I pulled the wrong tab. Chazen is equally horrifying, and you say in Chazen, this is something Senator Graham asked you. So the guidelines lay out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the 2 guidelines you disagree with is, one, there's an enhancement for use of a computer, and you say the world has changed and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre, and you say it in every case. You say the number of images, it's not an aggravating factor, it doesn't matter, and you won't apply the enhancement. Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not committed an offense that is more serious than someone that has a single picture of a single child? A single picture of a single child is horrifying, but hundreds of children that have been violated, do you really believe that is not a more serious offense?
Senator, I did not have any cases involving hundreds of thousands of pictures.
No, I said hundreds
and
or thousands. You had cases involving hundreds and you had cases involving thousands. You're right, you didn't have hundreds of thousands.
And I also applied an enhancement, just not to the degree of the guidelines.
You're
So
right, it's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
Okay,
not,
you're right,
not the
but-
suggestion
but,
that I
but
did.
are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with
So
respect.
let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list because we're running out of time. The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids being sexually assaulted. You have taken over a minute of my time, Mr. Chairman.
You've been given extra time. You usually ask for it. You're given it.
Okay, I know you want to interrupt. I know you don't like this line of
I just want you to play by the rules.
I know you like to interrupt, but you've consumed a substantial question of my time of my questioning, and I'm going to ask my questions, and you can, if you want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as every other senator.
In the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57 months.
Time has expired.
Why
Senators
did you
use 2
sentence
minutes
him to
over the
just
allotted.
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case. Why
Senator Coons.
did you sentence him for half the amount?
You're not recognized, Senator. Senator
Do
Coons.
you not want her to answer that question?
You wouldn't allow her any.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart.
You've
an
gone over the
egregious-
time, Senator, by 2 minutes.
Why she,
and a half.
because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an egregious...
There comes a point, Senator, where you get a little bit.
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to. The question is,
Senator
why
Coons, you may
did you
proceed.
sentence Stewart, an egregious child pornography possessor, to half of the amount
Please, Senator.
requested by the prosecutor?
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Why are you not allowing her to answer the question? There's
You're
not
over the
another
time
senator
by
here
2.5
that you've not allowed her to answer the question.
You're finished.
I'm not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman
Why
Durbin.
do you not want the American people to know what happened in the Stewart case or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and by the way, with Senator Graham, it went 10 minutes over. You've taken a big chunk of the time. Will you allow her to answer the question?
You've given her.
Why are you afraid of her? She's welcome to answer it right now. Will you let her?
Senator Coons.
Will you let? So no, you don't want her to answer the question?
Senator Coons.
Will you let her answer the question?
Chairman Durbin.
Apparently,
Judge
you are very afraid of the American people hearing the answer to that question.
We here in the Senate, in this committee today, are in the middle of a policy fight. It's my understanding that across this nation, more than 70% of district court judges who impose sentences in cases such as the ones that have been so vigorously debated here depart downwards from the sentencing guidelines, from the requests of the prosecutors. And as you've explained repeatedly and in detail, that's because a sentencing judge is required to weigh a whole series of factors. Opinions have you written as a judge, Your Honor?
I've written at least 570 opinions, Senator.
And in how many cases have you imposed sentences as a federal judge?
More than 100 cases.
And across all of those, we've just heard very forcefully assertions made about you and your character and your capabilities and your background, narrowing in on just a few. And I would simply put, for those who are watching and trying to understand what all of this is about, that in an attempt to distract from your broad support, your deep record, your outstanding intellectual and legal credentials, that we are taking what is a policy dispute that should be decided by members of the Senate. If we want to change the sentencing guidelines to make them mandatory rather than advisory, if we want to change the structure within which a federal judge imposes sentences, we could do that. But to demand that you be held accountable for this practice that is nationwide and is years old, I view as an unfair misrepresentation of your record. So if I could, let's go to something that you did as the vice chair of the Sentencing Commission, an important vote that you took in 2014. Because in my view, it shows how fundamentally misguided are the attacks that try to characterize you as someone who at all costs will do what you can to help criminal defendants. Let me just lay out the context for a moment. In 2010, Congress, enacting a policy choice, unanimously passed the Fair Sentencing Act, a bill that reduced the disparity in sentences between crack. Unanimously concluded this law meant those currently in prison on crack offenses could seek to shorten their sentences. 4 years later, the commission further concluded that individuals who provided substantial assistance to the government, people who cooperated, who helped out the prosecution, could use this law to shorten their sentence retroactively beyond any break they might have gotten for their cooperation. But you disagreed. In your public remarks at the time, you explained that although, given your prior service as a federal public defender, it might seem logical you'd support this direction, you could not do so because you concluded it was manifestly inconsistent with the law and would create unfair disparities between those previously sentenced cooperators and those sentenced today. Essentially, if I understand your view, it was that the sentence of a cooperator shouldn't be understood to be based on the sentencing ranges modified by the Fair Sentencing Act, but was best understood as a fixed discount of the mandatory minimum that a Fair Sentencing Act had not changed. I know this is technical, but I just wanted to make sure I'm characterizing this correctly before reaching a conclusion. Do I understand the context correctly in which you made this decision?
Yes, Senator, perfectly. It was debate among the commission, one of the very few in which we couldn't reach agreement about the retroactive application of the Fair Sentencing Act reduction.
And so just to finish the framing, the Sentencing Commission, which often decides things unanimously, was sharply divided. And here's who was on each side. You voted to deny relief to cooperators, to deny them a pathway towards reducing their prison sentences. And you were joined by two conservatives well known to us, Judge William Pryor and now Judge Dabney Friedrich. And the three of you were outvoted by four commissioners, which included Judge Hinojosa, an individual nominated by President Reagan and described as a hard-nosed, no-nonsense judicial conservative, who was on the other side of the argument from you. So you've got four commissioners, including an outstanding conservative Reagan nominee, and they thought the law could be interpreted to give a break on sentencing, and you were on the other side of that argument. If, as someone has tried to paint you, you simply were determined to give every break you could to criminal defendants, all you had to do was join the majority, and this would have passed. But that's not what you did. Help me understand why not.
Thank you, Senator. As you say, this is a sort of technical, kind of in the weeds discussion, but the top line is that when I looked at the issues and I looked at the law, it was my opinion that the law did not provide for the further reduction that was being considered.
So across an incredibly broad range of sentences you've had to impose and cases on which you've had to opine, I'm picking this one in part because it's not getting any attention in this confirmation process. But for folks who'd like some insight into how you make decisions and how you explain those decisions, there's a video, it's publicly available, of your April 2014 of the public meeting of the Sentencing Commission where you laid out your position. So I encourage folks to just watch that. And they'll see a jurist who understands that her commitment above all is to determine what the law requires and then follow it. In my view, that's an individual who belongs on the Supreme Court. By the way, your position that the law required that there not be further breaks given in this context ultimately won the day. My colleague from New Jersey made a point of mentioning a relevant case, United States versus Booker, yesterday. I have to say that in this case, it was decided in Coons versus United States with a K, not a C. Look, we all have our judicial record from which we work. But the Supreme Court ruled for exactly the same reasons you did in this argument that was made public. So I just think, Your Honor, this is an example of you looking hard at the law, making a tough decision, ultimately being vindicated in that decision, but taking a position that is not the caricature that's been proffered by some of you. Yesterday, I ran through a number of the letters and statements that debunk some of the attacks that have been levied based on a handful of sentencing decisions. There was the National Review piece by a conservative former prosecutor who calls out the smear on your sentencing practices in cases involving child pornography. The statement by the Fraternal Order of Police and the International Association of Chiefs of Police endorsing your even-handed and judicious approach to the law. The glowing letter from 24 prominent conservative attorneys and the resounding recommendation we heard in person from Judge Griffith. There's also been received here a letter from a number of retired federal judges, including 2 Republican nominees, rejecting this mischaracterization of your sentencing record. As I've said, this is a policy dispute that we should be deciding, not an appropriate basis on which to mischaracterize your record or your character. We have letters from the National Coalition of Domestic Violence in addition to these law enforcement leaders, from survivors, advocates, crime victims. The breadth of your support from the very communities my colleagues have suggested you're making less safe shows just how off base these attacks are, and in my view is a testament to your qualities and qualifications. So we all agree, all of us, that it's critical to protect our children and prevent the kinds of heinous crimes we've heard about in some detail earlier today. It's why I'm introducing a bipartisan reauthorization of the Victims of Child Abuse Act, something that we could act on as a committee to do our job, which is set policy and pass laws. But I also frankly think we need to be mindful that we are asking of you to get engaged in that policy dispute in front of this committee, which is not the role of a judge, something you well understand. Let me turn, if I could, to another reason I think you're deeply qualified and that you will bring something important to the Supreme Court. Brian Stevenson, one of America's leading civil rights lawyers and by happy coincidence a Delaware native, has spoken about how achieving justice requires being proximate to the people most impacted by the criminal justice system, and you've done that. As a public defender, you've represented individuals in the criminal justice system. As a district court judge, you have looked individuals in the eye and told them that for their crimes against society, they will spend years or decades in prison. You have met with, fought for, and advocated for victims. You've also studied the big picture. As an effective and engaged member of the Sentencing Commission, you've pored over data, reviewed thousands of letters, and thought hard about the appropriate national approach to just punishment in a more policy-oriented role. You've also thought about the big picture as a judge when considering the precedent that your opinions set. I'd be interested briefly in how your experience on the Sentencing Commission shaped your approach as a district court judge and how the interplay of all these factors might shape or contribute to your decisions as a Supreme Court justice.
Thank you, Senator. One of the things district judges, sentencing judges often say when asked about the task is that sentencing is the hardest thing that a judge has to do. And it's in part for the reasons that you have articulated, that it's one thing to understand the law, to read it in a book. It's one thing to look at data and numbers and make policy based on that. It's quite another on that individual. The work that I did on the Sentencing Commission, which was prior to my becoming a district judge, I think enabled me to understand unwarranted sentencing disparities, to understand some of the policy reasons behind the guidelines, and to make the kinds of evaluations that the law now requires since the guidelines are no longer mandatory. And I felt better in a sense about the task of calculating the guidelines, which is what courts have to do at the beginning of a sentence. They can be a little complex, and having been on the Sentencing Commission, I think that helped. And some of these cases do make their way to the Supreme Court. So I think that I am prepared to handle the cases that involve sentencing that do go to the court.
In preparing for this confirmation, I went back and read a lecture you gave, but it was later published in the Harvard Law Review about the balance, the challenge of sentencing, about that moment. I had the joy, the blessing of clerking for a judge on the Third Circuit. My legal skills and talents did not allow me the opportunity to clerk for the Supreme Court as you did, and also the District Court and also the Circuit Court. But I clerked for a judge who I first met when she was a district court judge and imposing a sentence on someone who was a crack dealer. And she did a remarkable job of speaking to the victims, speaking to the community, speaking to the prosecutor and the defense attorney, and then speaking directly to the defendant in imposing a very long sentence. And as I got to know her later, I recognized that, as a member of our community and as someone who saw the importance of that moment, that public moment, of helping the defendant understand what they'd done so that they might somehow change, but also helping the victims understand what had happened, that she took that very seriously, incredibly seriously. In the Harvard Law Review publication of your remarks, you said that you're persuaded by the theories of punishment that accept all human beings are responsible moral agents, and you view punishment as a necessary consequence of the defendant's decision to engage in criminal behavior. You also went on to say that the challenge is balancing the acknowledgement all of us are more than just the worst thing we've ever done, but there is a need to ensure the defendant is adequately addressed and punished. What I think you say in that lecture, what you've shown across the arc of your public service, reveals someone who understands the appropriate need for punishment in our society, but who is also striving to follow the balance of recommendations, guidelines, statute, and the context and facts. And I trust that as members of this committee and the Senate as a whole and the general public take the time, which they should do, to give a fair reading to the whole scope and arc and reach of your service, that they'll see you as someone who cares deeply about our Constitution and the rights that make us free, as you said in your opening statement. Your career in the law, your service on the bench, your thoughtful responses to questions put to you, the way you've maintained your composure, all impress me. As I mentioned, I don't think labels such as a judicial philosophy are always that meaningful or dispositive. I think in your case, a deep admiration for the Constitution and an understanding that the role of a judge is a limited one are critical and qualifying. You opened yesterday by referencing how your parents were educated in racially segregated schools in Florida, but how you, just one generation later, were raised in integrated schools and had far greater opportunities to put your evident God-given talents to work in service to our nation. You cited this one generation change as an example of the greatness of America. Of course, the Supreme Court played a central role in more correctly interpreting the Constitution and applying it in a manner that allowed this reversal of unjust law to occur. I think the experiences of your own family and your connection to the experiences of trailblazers who came before you, on whose shoulders you stand, has meaningfully shaped what kind of a justice you will be. I think you know in your bones how important our Constitution and the rule of law is. And I think, as someone who served on the Sentencing Commission, a public defender on the trial court, and appellate court judge, you have the ability to see across the whole scope and reach of how the law impacts families, communities, and our nation. Last, in some ways, I think, most importantly, I've learned that as a person and a judge, you have humility. Judge Griffith, who came before this committee to introduce you, and scores of others we've heard from, I've just referenced, have lauded your practice of judicial restraint. And you've said a core component of your philosophy is your understanding that the judge's role is a limited one. Well, I think restraint is a core part of your approach to decision-making, partly because you are a judge who is humble enough to know that the Constitution and the laws passed by Congress say what the law is. The judge has a limited role in deciding questions of law based on facts presented. Penn Law professor Lisa Fairfax, your other introducer, your dear friend, explained that since college at Harvard and then through law school, you've been a mentor and a role model. She praised your warmth and intelligence, your devotion to friends and family, but she also mentioned your humility. She knew you were honored and humbled by the significance of this moment, not what it means for you, but what it means for our nation. I remember thinking about this on Monday. I had a chance to talk to your brother, Kataj, and he mentioned that he knew you were destined for this moment your whole life. I am sure he would say you've been exceptional since you were student body president at Palmetto High School. I suspect your wonderful family upbringing is partly responsible for this facet of your character. I suspect your faith has played a role in sustaining you, as mine does, and so does many others in this room. I've often found instruction and comfort in the verse, "What does the Lord require of you but to do justice, love mercy, and walk humbly with your God?" Now, I'm not going to ask you to reflect on that verse, Your Honor, but I wouldn't be surprised if it's one of your favorites that sustains you. Let me close by returning to what Judge Griffith said when he told us in his heartfelt introduction of you on Monday, and something you've also shown in the hours you've been grilled by this body. He had already written a letter to this committee delivering his endorsement. He took the extra step to then amplify it in person. And he did so because of confidence in you and because he was delivering a message to us as a committee that Supreme Court confirmations should be more than just exercises in partisan tribalism. He said there should be nothing unusual about a judge who just happened to be appointed by a Republican president and who holds conservative legal views coming forward to support a nominee with your impeccable qualifications and character, especially a nominee whose legal opinions, whose actions and decisions as a judge, he was in a position to review for years, given that you were a district court judge and he was a circuit court judge. Look, our confirmation hearings for justices have sadly been devolving over many years into longer and longer exercises of partisan politics, punctuated by just brief glimpses and occasional thoughtful examinations of a nominee's judicial decision-making and views on the Constitution, which should properly be our main focus. I have to believe this sad state of affairs troubles my colleagues of both sides and all who watch this. But as I reflect
its government, including all three branches. So I would ask you, do you agree with these characterizations of the court that have been levied in this room over the last few days?
Senator, I have nothing but respect for my former judicial colleagues, my current judicial colleagues, and hopefully my future judicial colleagues. I do believe that we need legitimacy. I've said that that's the currency of the court, and I look forward, if I'm confirmed, to joining the institution.
So do you think there could be any opinion that would be handed down this term that could undermine the legitimacy of the court?
Senator, I think the Supreme Court makes its determinations, and all of them are precedents, and they are entitled to respect.
I'd like to come back to our conversation from yesterday. You pointed out a number of times that as both a district and now a circuit court judge, you were constrained and bound by the Supreme Court's holdings. You mentioned a couple of times that you haven't had a chance to do much constitutional interpretation for yourself. I largely agree with the way you framed most of that for the lower courts, but I think you would also agree with me that the job of a Supreme Court justice is different than a district court judge, and in certain ways from a circuit judge as well. When you serve on the Supreme Court, you'll have to interpret what the Constitution means, and based on what you told us about the constrained role on the lower courts, lower court decisions would then not be able to answer how you would approach the new job you would have on that highest court. And so that's why I thought our conversation on judicial philosophy yesterday was somewhat helpful. I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, were good for the court, and were good for the public more broadly. So I guess I would ask you, if you could take us to law school one more time and walk us through some of the different approaches to substantive due process and unenumerated rights. What are the different ideas on the Supreme Court and in the broader legal community?
Thank you, Senator. I am not mostly familiar with the Supreme Court's precedents in this area. It's been a while now that the Supreme Court has determined that the 14th Amendment, which guarantees due process, includes a substantive component in addition to procedure. The term due process, one would think, is just about the procedures that the government has to afford you before it affects your life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy, and that are deeply rooted in our nation's history and traditions, or implicit in the concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage, interracial marriage, the access to contraception, a woman's right to terminate her pregnancy, abortion, pursuant to or subject to the framework established in Roe and Casey, travel, the child rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I am not able to forecast. In every case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I have been going back and forth on over the course of a couple of weeks, because I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia, is important, and you wouldn't claim any of those philosophies for yourself. And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific limited and defined principles or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said, and I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like, I believe we still haven't heard your judicial philosophy, and I wish I'd made more progress with you on that. But what we do know on a personal note is that these committee 3 days have been very long, and I want to thank you, and got to have a nice conversation with your parents earlier, your whole family, for what you've endured, and for spending time with us, and obviously best wishes to you and your family. Thank you, Judge.
Thank you.
One more minute.
Thank you, Senator Sass, and Senator Blumenthal is next.
Thanks, Mr. Chairman. Good afternoon.
Good afternoon.
Judge Jackson. I know your birthday, September 14th.
Yes, sir.
You have the happy coincidence of a birthday with Constance Baker Motley,
Yes, sir.
who just happens to have been born in New Haven, Connecticut.
Ah,
And we're very proud that she is a daughter of New Haven and Connecticut. And she is one of my heroes as well. As you know about her, she was the first Black woman appointed to the federal bench. She is the first Black woman to have argued before the United States Supreme Court. In fact, her record before the court was 10 wins and 0 losses. She was very predominantly responsible for Brown versus Board of Education. Thurgood Marshall got most of the credit, but she did a lot of the work. Probably sounds familiar to you. So why don't you tell us, and maybe tell those folks, particularly women and girls who are watching or listening, why you said at the outset of the hearings here that she was one of those whose shoulders you stood upon as you came here today.
Thank you, Senator. Well, in addition to the fact that we share a birthday, which I discovered when I was in law school and thought, what a happy coincidence in terms of someone who I so admired. And secretly at that point, I was thinking maybe I might want to be a judge. So it was a wonderful, wonderful coincidence. I so admired the fact that she was the first. It's not necessarily easy to be the first, but it is an opportunity to show other people what is possible. When you're the first, it means no one has ever done it before like you, and there may be hundreds, thousands of people who might have wanted that opportunity and thought, I can't do that because there's no one there like me. And so being a trailblazer, whether it's Judge Motley or Justice Marshall or Justice O'Connor, being a trailblazer is really inspiring, I think, and I was always moved by Judge Motley's experience, and think it may even be part of why I moved in this direction.
Well, it is inspiring, and I hope that your very inspiring story will make it possible for a lot of others to think it not secretly, but say it out loud and aspire to it, because it's what this country needs. And fortunately, President Biden has recognized it in the nominees that he's put before us, and we've tried to work with the great leadership of Senator Durbin to confirm people of real merit, the kind of qualifications in intellect and character and depth and warmth that you bring to us today. I want to talk a little bit about voting rights, because part of the reason why those dreams now are realities is that more people have the right to vote, at least until recently. In fact, there has been a lot of backsliding about turning back the clock on voting rights. The gentleman sitting behind you, Doug Jones, our former colleague, whom we very much respect and admire, wrote a tribute to Vivian Malone Jones, who has a rich story as a civil rights warrior and who succeeded John Lewis as head of the Voter Rights Project. And he said in a speech that Doug Jones wrote in tribute to her as she was inducted posthumously into the Alabama Women's Hall of Fame, I'm quoting, "We can best honor her by acknowledging that while most doors are unlocked today, they are still heavy and so hard to open for so many people in Alabama and the rest of the nation. Let us commit ourselves to do our part to open these doors as wide as possible so that everyone can take the walk that Vivian took." I'm going to ask that former Senator Jones' full speech be entered in the record, Mr. Chairman. Thank you. The simple fact of the matter is, Judge Jackson, Congress passed the Voting Rights Act in 1965. It was a source of real power to so many people who got the right to vote for the first time in practical terms, because it struck down more than 1,000 discriminatory election rules proposed by state and local officials. It opened the ballot box to millions and millions of Americans, and it became regarded as the crown jewel of the civil rights movement. And then, just in the last few years, the Supreme Court has hacked away at it in an exercise of judicial activism that has been historic in magnitude. Judges supplanting their views for the policy preferences and official acts of legislatures. In opinions that were written and joined by only conservative justices, these decisions were about as far from judicial restraint as they could possibly be, not even close. And they rewrote the rules of our most cherished and most bipartisan civil rights laws. You know the cases, Shelby County, Brnovich versus Democratic National Committee. In effect, their opinions, including Justice Alito's decision in Brnovich, are completely untethered from the clear statutory text and they impose a series of so-called guideposts on Section 2 that create unreasonably high hurdles to the exercise of the Voting Rights Act. I hope that you will bring to the court that deliberate, careful methodology that you described earlier very convincingly. It is part of your judicial philosophy in the sense that it's your approach to cases. And it has been very persuasively and clearly articulated. And I think if that kind of deliberate and careful methodology had prevailed on the United States Supreme Court, we would still have the Voting Rights Act in full right now. And I hope that we can once again return to bipartisan support of those rights. The most recent exercise of unfortunate decision-making in the voting rights area came just hours ago when the Supreme Court struck down the decision of the Wisconsin State Supreme Court in Wisconsin Legislature versus Wisconsin Elections Commission. What is striking is not only the result, but the fact that it was done as part of the shadow docket. We've talked a lot about it here, and what the people of America should know is there's no oral argument, there's only minimal briefing, there are no full opinions of the court. In fact, I'm holding up a per curiam opinion that is about 12 pages in length from the court, which means you don't know who wrote it. And there is a powerful dissent. I recommend that everyone read it. Again, use of the shadow docket has become increasingly prevalent since 2017, and in effect, the United States Supreme Court is shirking its duty. I hope you will bring to the court the kind of responsible and methodical approach to decision-making that will lead to an avoidance of the shadow docket, as well as a return to the Voting Rights Act. And if I can just offer one more piece of advice on the court's workload, I have a chart. I know we're not going by the rules of evidence here, but this chart indicates the signed decisions of the United States Supreme Court over a good part of its history. And I think the pattern here is pretty clear. The court issues fewer signed opinions. In fact, it has declined precipitously since 1972. This little blip at the end here is an increase from 53 to 57, but you can see it's only a fraction of what the court used to do in signed opinions. Even from the time when I was a law clerk, it's diminished profoundly. The Supreme Court needs to do its job. It needs to issue signed opinions, not the shadow docket. It needs to take cases and resolve real, fundamental, important issues. And taking your record, 573 opinions over 9 years. I'm not a math major, but that's about 64 opinions a year. That's a lot more than they do, all 9 of them. So I hope you will bring the energy that you have demonstrated in this room, the energy and the work ethic to the United States Supreme Court, because clearly you have both. And I think the court is very much in need of it, as it is some of the other great qualities, intellect, character, that you have demonstrated here. Just a couple more points, if I may. You were asked earlier about dissents. I want to ask you about one in particular, the dissent of your mentor and your predecessor on the court, Justice Breyer. I am told, I think I've read, that there is one opinion that he is proudest of. Could you tell us what you recall it being, if you know?
Senator, I'm not able to answer that question.
Well, I think he said that the dissent that he is proudest of was in parents involved in community schools versus Seattle School District. I think he said it was the opinion that he was proudest of, and he cited it in a Harvard Law School symposium about his notable opinions, and he said this dissent was most notable. I will give you the citation when we're done, and ask that it be entered into the record, Mr. Chairman.
Without objection.
It's 77 pages long, and it's a dissent. It's a dissent in the parents involved case, which was a 5-justice plurality invalidating public school integration plans in Seattle and Louisville. The plans had been in place for decades, put in place by 2 local school boards, voluntarily trying to address school segregation in public schools in both of those cities. And the justices, conservative justices, striking down the school integration plans said, in effect, they couldn't move forward with those integration plans. You may recall it is the opinion where Chief Justice Roberts said, very famously, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Justice Breyer, in dissent, which reminded me of a lot of what you've said here this week, wrote, quote, "I do not claim to know how best to stop harmful discrimination, how best to create a society that includes all Americans, how best to overcome our serious problems of increasing de facto segregation. But as a judge, I do know that the Constitution does not authorize judges to dictate solutions to these problems. Rather, the Constitution creates a democratic political system through which the people themselves, through their legislators, must together find answers. The court should leave them to their work." I think that's the philosophy that you've articulated here today, the judicial philosophy of separate branches of government, as you so eloquently described our constitutional scheme, our federalism that really should have led the court to respect the Wisconsin Supreme Court's decision and the Wisconsin governor's decision, and to stay in its lane, as you have put it so well. The fact is, there has been a lot of progress, and we see it in this hearing room. But there is a lot of work still to be done, and there's a lot of reason for folks to feel even some anger at what we've seen on voting rights and on resegregation. in some areas. So I am really excited, as I've indicated, and joyful at the great landmark and the historic accomplishment that your nomination represents and reflects. And I hope, as I've said, that not only will you make the court look more like America, but hopefully think more like America. And I want to thank you for your very hard work, all of what you personally have done, because you as a person have done it. And history has given you this opportunity. Your parents have helped to make it possible. Your family story is so powerful, but you've really earned it. And we're grateful to you for providing all of us that role model. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Hawley.
Thank you, Mr. Chairman. Judge, good to see you again.
Good to see you, Senator.
We don't have a lot of time, so let me just get straight into it. Senator Cruz was asking you at the end of his time and questionings about United States versus Stewart. This is the case where Neil Stewart tried to cross state lines to rape another person's 9-year-old daughter. He had 6,700 images and videos of egregious and brutal child pornography. The government recommended 97 months. The guidelines said 97 to 121 months. You came in at 57 months. Senator Cruz asked you why. The chairman wouldn't let you answer. I thought maybe you'd like to answer now.
Thank you, Senator. No one case can stand in for a judge's entire record. I have sentenced more than 100 people in a variety of egregious circumstances. In every case, and especially cases that involve the kinds of acts that you're talking about, the kinds of evidence that I had to deal with as a judge, in every case, I am balancing the factors that Congress has determined are appropriate and required for a judge to make a determination. The data points that Senator Cruz pointed to that you may have in front of you don't account for all of the information that was before me as a judge and the authority that you all, Congress, and your prior confirmation when I was a district judge provided for me to exercise my judgment. And I treated those cases and every case very seriously and imposed a sentence that was sufficient but not greater than necessary to promote the purposes of punishment.
Would it surprise you to learn that Mr. Stewart's a recidivist? He was warrants issued again for his arrest just 3 years after you sentenced him?
Would it surprise me?
Yeah. Would it surprise you?
You know, Senator, there is data in the Sentencing Commission and elsewhere that indicates that there are recidivism, serious recidivism issues. And so among the various people that I've sentenced, I'm not surprised that there are people who reoffend, and it is a terrible thing that happens in our system.
Yeah, indeed it is. Let me ask you about the Hawkins case. You and I talked about this yesterday. You've been able to think about it overnight. This is a case where you had an 18-year-old who possessed and distributed hundreds of images of 8-year-olds and 9-year-olds and 10-year-olds, and you gave him, frankly, a slap on the wrist sentence of 3 months.
Senator,
Do you regret it?
I don't remember whether it was distribution or possession in
It was
the law.
both. Do you regret it?
In the law, there are different crimes that people commit
Judge, you
in
gave
this
him 3
area.
months. My question is, do you regret it or not?
Senator, what I regret is that in a hearing about my qualifications to be a justice on the Supreme Court, we've spent a lot of time focusing on this small subset of my sentences, and I've tried to explain.
You regret that
many
we're focusing on
times-
your cases? I don't understand.
No. I'm talking about the fact that you're talking about
Child pornography
7
cases?
very serious cases.
I'm glad we agree on that. Don't you think we should be focusing on that?
Some of which involve conduct that I sentence people to 25, 30 years.
3 months
for-
in this case, Judge. Do you regret it? You haven't answered my question yet. Do you
Senator.
regret this sentence?
Senator, I would have to look at the circumstances. What I'm telling you,
You know the circumstances. We discussed it for half an hour yesterday. There's a 55-page transcript, which I'm sure you've read. You
I
lived
did
it.
not- I
As
did
you've
not-
emphasized to this committee over and over, you've lived it, right? You said that you've been through all of this. You've looked at all of the images. You're the one who's had to endure all of it. You gave him a 3-month sentence. I just wonder if you regret it or if you stand by it. I mean, do you stand by that sentence?
Senator, in every case, I followed what Congress authorized me to do in looking to the best of my ability at all of the various factors that apply, that constrain judges, that give us discretion, but also tell us how to sentence. And I ruled in every case based on all of the relevant factors.
So you don't regret it?
No one case, Senator, can stand in for a judge's
I'm not asking you that.
entire
I'm asking you
record.
if you regret this sentence in this case. And it sounds like the answer is no. But I want to tell you I regret it. I regret that you gave him only 3 months. Let me read to you what you said about these kinds of cases. In fact, to this defendant, you said, "Make no mistake, Mr. Hawkins, the children you saw in those pictures were not willing participants in the conduct that you witnessed. They were being forced to commit unspeakable acts of sexual violence for the pleasure of the person who was filming and for the gratification of sick people everywhere, people who apparently have no shred of empathy for what this must be doing to the children who are being abused in this way." You go on. Some of the children you saw in those pictures will never have a normal adult relationship. Some of them will turn to drugs and prostitution and other vices to try to deal emotionally with the pain that results from the torture that they have experienced. And even those who manage to lead a somewhat normal adult life say they live in constant fear of being recognized. Some people are even unable to leave their houses because once those pictures are on the internet, they are there forever. And the victims can't do anything without worrying that every person that they meet has seen them in their most vulnerable state at the most horrible time in their lives. That's your words, pages 34 and 35 of the transcript. Powerful words, Judge. I just don't understand why after saying this and believing this, you could give this guy 3 months in prison when the probation office that we've heard so much about recommended 18 months. Even the probation office recommended 18 months. Do you have anything to add?
No, Senator.
Let me ask you about your policy of not giving enhancements when there are prepubescent children, like there were in the Hawkins case, who are 8, 9, 10 years old, when there are prepubescent children involved. I'm just struggling to understand this. You said it in Hawkins. You said that you weren't going to give him an enhancement. You weren't going to make his sentence any tougher, despite the fact that we had all of these terrible videos that you and I talked about at length yesterday. This is page 38 of the transcript, just so that we're all following along. You said, "In your case, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer," and we've talked about that, "or the number of images or prepubescent victims as the guidelines require, because these circumstances exist in many cases, if not most, and they don't signal an especially heinous or egregious child pornography offense." You said the same thing in the Cooper case just last year. This was an individual, Cooper, who was 30 years old at the time of his sentencing. He pleaded guilty to distributing child pornography. He posted between 3 and 4 dozen images of child exploitation to Tumblr, where it could be accessed publicly. The government said, and I'll quote from the transcript in that case, page 37, when his devices were found, including the computer, within the computer and on an untitled folder were many, many, many videos. The nature of these videos went well beyond mere child pornography. The government says, I don't mean to make light of the content of any child pornography, but rather to say that the content of those videos is on the more egregious or extreme spectrum of the child pornography videos that are encountered in these cases. And yet, when you sentenced him, you said, I'm quoting now from the transcript in Cooper, "I'm really reluctant to get into the nature of the porn." And then later, "It's very difficult to assess how different Mr. Cooper's images are than those of other similarly situated child pornography defendants, such that I, without going into looking at them, and I'm not an expert, you say. So you say, while I understand the government's arguments, Mr. Miranda, the government's arguments in that regard, I don't find them persuasive from the standpoint of characterizing this as an especially egregious child pornography offense. Help me understand this, Judge. Why is it that what's your policy disagreement with the guidelines treating images, videos, pornographic images that have small children, infants, 7, 8, 9-year-olds? Why won't you give an enhancement for those? Help me understand that.
Thank you, Senator. I'll make 2 responses. First, that's not my policy disagreement. I don't know why you've characterized that in that way.
Well, wait a minute. You say right here in the cases. I mean, this is what I want to make sure that we're talking about the same thing here. This, in the Hawkins case, I don't feel that it's appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims. And you say the same thing in Cooper.
Senator, 2 observations. 1, I am sentencing in every case. I have policy disagreements with certain aspects of the operation of the guidelines that I lay out in every case as Congress has required and as the Supreme Court permits in light of my experience, not only as a district judge, but also on the Sentencing Commission, which did a report about the operation of the guidelines. Second, you've read extensively from the government's argument in this case. You've not provided information from the probation office or the defense. And when
I don't have the probation office report.
No, excuse me, Senator. The probation office provides a recommendation. There has been information gathered about what a recommendation was given in each one of these cases. I don't have that information here, but what I'm saying is that in every case, the judge is not just hearing from the government. The judge is not just evaluating what the government says in these cases. In every criminal case, a judge has to take into account all sorts of factors, including arguments being made by the defendant, by the government, by the probation office. So I understand that in certain cases, the government may have made an argument, but there are other people in our criminal justice system who make arguments, and the court evaluates everything as Congress has directed, and no one case can stand in for my entire record of how I deal with criminal cases, or did when I was a district judge. I have law enforcement in my family. I am a mother who has daughters who took these cases home with me at night because they are so graphic in terms of the kinds of images that you are describing. They give you not only the actual videos, which you can ask to see, but they describe in the briefs in detail what these videos show. So I am fully aware of the seriousness of this offense and also my obligation to take into account all of the various aspects of the crime as Congress has required me to do, and I made a determination seriously in each case.
What I'm trying to understand is, why is it that you say multiple times that just because there are prepubescent victims in Cooper, in Hawkins, that does not signal that this is a heinous or egregious child pornography offense, and you're not going to apply any sentencing enhancements that the government's asking you for? The sentence gets to be less because you say, I'm not going to apply. The government asked for enhancements related to prepubescent children, related to the nature of these images. You say, I'm not going to apply it. But what you're telling me is, I guess, that you don't have a policy objection? I mean, why didn't you apply the enhancements as they were asked for?
Senator, I've answered this question many times from many senators who've asked me, so I'll stand on what I've already said.
So you have nothing to add about images, in your view, do not signal an especially heinous or egregious child pornography offense.
Danced around the question.
You say
Sorry.
in Cooper, I understand the government's argument, but I don't find them persuasive, the fact that there were prepubescent children, from the standpoint of characterizing this as an especially egregious child pornography offense. That's page 58. Let me ask you this. You said to Senator Graham earlier today that you were trying to do what's rational, and you didn't in sentencing in these cases, and you didn't think it was rational to sentence people who had thousands of images by using a computer to the sentencing guidelines, to the mandatory range. I'm sorry, it's not mandatory, to the no longer mandatory range, the discretionary range.
No, Senator, I said the guidelines system is designed to be rational.
Okay, so let me ask you this. Why isn't it rational to sentence people who have thousands of images on a computer to more time as opposed to somebody who has one or two pictures in the mail? In other words, the more images there are, why wouldn't you want to sentence that person to more time rather than less? Why isn't that rational?
Senator, I've answered this question, and I'll stand on what I already answered.
So, but your answer is what? I mean, refresh my memory.
Senator, I've answered this question. I've explained how the guidelines work, and I'll stand on my answer.
But the guidelines are not mandatory. I wish they were, but they're not. The Supreme Court made that determination. I'm trying to understand why you think it's rational not to sentence criminals based on the number of images they have. You say that this is a policy disagreement that you have with the guidelines. This gets to the core of your judicial philosophy. You served on the Sentencing Commission, where you recommended changes to the guidelines based in part on this policy disagreement. So I think it's relevant and indeed vital we understand what the policy disagreement is. That's what I'm trying to get at here.
Senator, I previously explained what the policy disagreement is, and I will stand on my answer.
So you're not going to answer my question?
No, I've answered your question in my answer.
You haven't answered my question. I'm sitting here asking you, and you're declining to answer.
I've explained how the guidelines work. I've explained that the guidelines were developed at a time in which the commission of this crime was different than it is today. I've explained that Congress has not intervened to revise or direct the commission around how to deal with the changes in the commission of this crime. And so judges all over the country are grappling with how to apply this guideline under these circumstances. And there's an extreme amount of disparity. And in each case, a judge has to look at all of the factors, not just the guidelines, not just what the government asks for, but the recommendations of the probation office, the arguments of the government and the defense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote the purposes of punishment, which include things like rehabilitation. Also, in every case, Congress has authorized judges to impose not only terms of imprisonment, which are a very important part of the consequences for these crimes, but a range of other preventative kinds
And she
of
never answers
measures
the question.
which courts impose in cases to prevent these defendants from repeating these egregious, this type of egregious conduct. And I talked to each defendant, as you have quoted, explaining to them the harms that their crimes caused, and I imposed not only a term of imprisonment, but also all of the other consequences of the offense, to include decades of supervision, restrictions on use of a computer, and the like. That's my answer. I've answered it many times. Do you have other questions for me?
Yeah, I do. I do, because I want to try to understand when you talk about the guidelines being outdated and outmoded. I understand that they were written, the initial guidelines were written at a time when computers were not common. Everybody didn't have one. Certainly didn't have phones in every pocket like we do now, smartphones. So I understand that. I also understand that the number of images, sexually exploitative images of children on these devices has exploded. And so I'm trying to get at what Senator Coons earlier characterized as a pretty fundamental policy question, which I think is the correct characterization here. I'm trying to understand your view on why it is that while the number of images available on these things has exploded, that sentencing shouldn't track that. You see what I'm saying? I mean, you've made the argument, if I understand you right, and I want you to correct me if I'm wrong, you've made the argument that, well, look, the guidelines were written at a time when this stuff was like, it was an individual picture, it was, magazines, whatever. Now, almost every offender, I think this is the argument, so you correct me. Almost every offender, because of the nature of this, they've got tens, hundreds, sometimes thousands. I mean, partly because of the nature of this. My question to you is, wouldn't we want to deter that? Isn't that a reason to impose tougher sentences? I mean,
Senator,
go ahead.
the Congress has every ability to do that. What's happening now is that you have a guideline that has gradations in it for the number of images that ends up being, when you look at the scale, something like the difference of 10 years. I don't know exactly what it is, but each two-level enhancement is like several years. And the gradations are like 0 to, and again, I don't have it in front of me, but it's like 0 to 50 pictures, 50 to 100 pictures, 100 to 150 pictures, set up at a time in which the mail was the primary mode of possession and distribution. And so if somebody had 50 pictures, they, according to Congress and the commission at the time, deserved an extra 10 years in prison. Now, with that scale, everybody's at the top immediately, just because of the nature of the internet. So you're not differentiating using that scale anymore, given the way this crime is committed. And so judges are having to decide, how are we going to deal with the penalties and do our jobs to impose sentences that are sufficient but not greater than necessary under these circumstances.
Yep. Thank you, Judge. I'll just say in closing that I appreciate that answer, and I understand that as a policy matter. I just think we disagree. I think that the more images are there, the more punishment there should be, and I want to see this deterred. And I just think we've pretty fundamentally disagreed. I've enjoyed our exchanges. Thank you for your candor, and I appreciate it. I just disagree with you on the law. Thank you, Mr. Chairman.
Senator Hirono?
Mr. Chairman. Mr. Chairman.
Senator Hirono's turn.
Mr. Chairman,
Mr. Chairman.
I'm asking to be recognized to make a point to the chairman.
Mr. Chairman.
I believe he recognized me. May I proceed?
Mr. Chairman.
Mr. Chairman, I waited my turn on here, and I've been on this committee for 47 years. I think we ought to follow the regular order.
Mr. Chairman, the witness just said that we cannot understand those cases
sorry,
without
Senator,
the pre-sentence reports.
I don't want to go through this again.
I have a letter that I want to enter into the record that's signed by 10 senators on this committee. Are you not even going to allow a letter from 10 senators on this committee?
Send any letter, you can do it by hand,
This letter
by
that is
mail.
signed by 10 senators on the committee addressed to you makes the point that the White House gave you probation information for Democrats that was not provided to the minority on this committee. And just now, Judge Jackson told Senator Hawley, you cannot understand these cases without reading the probation reports. 10 senators on this committee are asking the chairman
Mr. Chairman,
to provide those reports so we can do what Judge Jackson
Mr.
just
Chairman,
said, which is
I
to
know
assess
the-
those reports. And
Mr.
here is the
Chairman,
letter.
I know
I
the
ask
ju-
unanimous
know the
consent that it
junior
be admitted to
senator-
the record.
I know the junior senator from Texas likes to get on television, but most of us have been here a long time trying to follow the rules. And he could very easily hand you a letter to go in the record. He's saying he's doing this to help Senator Hawley. Senator Hawley could have put it in, and he didn't. But let's get back to regular order.
Senator Hawley didn't write the letter. Mr.
Let's get
Chairman, I
back to
ask
regular
unanimous
order.
consent that it be admitted to the record.
Senator Hirono.
Thank you.
Are you denying consent?
Thank you, Mr. Chairman. Aloha, Judge Jackson.
Aloha.
I'm going to try and spread some.
Wow. Wow. Not even. Not even. Okay, well, I'm going to shut it down for tonight. It's been going for almost 7 hours. Thank you all for watching. Tomorrow may be a regular day. I don't know. We'll see what they have coming up. I just can't take another 4 hours of this. That chairman won't even recognize Ted Cruz. Not at all. He dislikes him. Oh well. Oh well. Thank you all for tuning in. I'll see you tomorrow. God bless you, and may God be with you. God shine His light upon you. May God shine His light upon your path, and may you follow that light. Have a great day, folks.